and let's get rocking and rolling if there's no questions. If you guys have questions as I go through the lecture, type it in the chat bar. If you see I pause or I ask, at that point would be ideal. If you want to interrupt me, I love, you know, that to have an engagement. If not, it just sounds like I hear my own voice, and it makes it a little bit more difficult on me. But real estate brokerage, its actual definition isn't really what I want you to know. Really, it's brokerage, right? It's bringing together buyers and sellers. If you're a stockbroker, it's bringing together, you know, shareholders and corporations. What I want you to know, and this might be the most important thing that you need to know when you go into this test, is that the broker owns everything. Any money that comes into the office must go through the broker, whether tangibly through him or whether he grants permission for the sales associate to receive that money directly. But sales associates cannot collect money without the consent of the broker. The broker chooses what authorized relationships the company is going to be using, the brokerage. The brokers chooses what's the commission split. The broker chooses that we don't sell businesses. We only sell commercial. We don't sell houses under $500,000. Okay? The broker calls all the shots. Your brother, your sister, your mother, your kids, whatever it may be, a family member, your best friend wants to buy or sell a house with you. Whose customer or client is that? Yours? Question mark?
The broker.
The broker. So I can't stress enough, guys, you need to go in with that mentality. Ethical egoism is a philosophy. And it's that we all work for ourselves. Even if we do good for others, right? We do it for our own pleasure, believe it or not. And I truly believe, as I have a minor in philosophy, that we do that, even if it's for our own kids. So I hate to put it this way, but you want to walk into this exam and, you know, realize that you will be nobody in the office. And I make it that, like, I guess, abrupt, just so it sticks. Now, in the real world, real quick, depends on who you go work with, they're going to give you a little more leeway than others. But the state wants you to believe that you make no decisions whatsoever. Any advertising, you have to take it to the broker before you do it, blah, blah, blah. Every broker is different, but for state purposes, default to you make no decisions and do nothing on your own. Second most important slide in the book, to be honest. The first two are the most important. You need to know the definition of the 5 major sales specialty. In reality, you want to know the definition of 3 of them. Residential being most important, because if I otherwise state, we're talking residential. They throw in commercial here and there in this coursework, but I want you to know that commercial real estate is caveat emptor. We'll run into that in chapter 4. Caveat emptor is also on the state, and it's Latin for let the buyer beware. Commercial real estate is very unregulated. I say that commercial real estate agents walk around with knives in their mouths, to be honest. Now, what is residential? Residential is vacant land zoned for 4 units or less, 4 units or less of improved land, and 10 acres or less of land. Now, when we talk about 4 units or less, we're talking about a single family home, a townhome, a condo, a duplex, a triplex, a fourplex, right? Anybody ever hear of a fiveplex?
Nope.
No. Why? Because that's an apartment building at that point, okay? And an apartment building is considered to be commercial. Now let's talk about the difference between an apartment building and a condo, because some of them may look exactly alike outside. The difference is the ownership interest. A condo is single family wide because each unit has a deed. So unit 101 is owned by Mary Smith. Unit 506 is owned by Juan Gonzalez, and so on and so forth. Where an apartment complex, when it's 5 units or more, has one deed owned by maybe a group of investors, a corporation, maybe it's owned by George Suarez. But there's one deed for the entire complex, where condos, each unit has a deed. Know the difference, okay? They're going to try to get you to slip up and not know the difference between an apartment and a condo. Now, commercial, outside of those 5 units or more, it's very self-explanatory. I'm sitting in an office space right now, shopping centers, things like that. Outside of the 5 units or more of the apartment, don't worry about it too much. Industrial, agricultural, don't worry about too much, but I'm going to tell you there's this dumb question on the state exam. If you've taken it, you may have seen it. It's the online state exam right now is really dumbed down. And it tells you something about an agent who is well-versed in farming and the hardships and the mortgages that benefit farmers would be practicing what type of sales specialty, and you would say agricultural. Okay, so that's on the state exam. They really never asked about agricultural. I don't know how much more obvious that can be. If anybody's seen it, that's just one of the easy ones. And let me ask you a question now. How many of you have taken the course online? The state exam online, sorry, not the course.
I have.
You have.
I have.
Do you feel like it's have you now, how many of you that have taken it online also took it live? You've gone various times. You took it one time live, you've taken it online.
I took it once live, but it was like a year ago.
Yeah, I did too.
Okay, how, even a year ago compared to now, you can attest to that the live test is way harder than the online one as far as the wording. Would you agree with that statement?
Yes.
All right. I just want everybody here to know that, because if you want to wait a month and a half because you can't do it at home, blah, 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 trust me, take it online while they're offering it. It is dumbed down. Okay? They have questions like that that are just like so obvious. And I'm not going to say that the test is easy, right? But it's easier than taking it online. Now, where somebody told me, well, they took it live a year ago and then you just took it online. Well, that the problem there is, and for my students that are here, why I harp on you guys to take the class, take the test.
Okay.
Because this information, you know, we don't retain it like we, you know, I'm 41, you know, some of you I know are younger, but it's a lot of information, you know, like I trim the fat for you guys, but the longer you wait, the more difficult it becomes. And those that are here that took it a year ago can attest to this. All right, businesses. Businesses pops up on the state exam. It's in chapter 17, which is 1% of the state exam. We can cover that chapter right now, right? You need a real estate license in the state of Florida to sell businesses, okay? Licensees who engage in the sale of businesses are known as business brokers. Do not fall for the fact that there is a business broker's license. There is no such thing. It's a nickname. In order to sell businesses, and you're an associate, you have to have a broker, and the broker has to give you the blessing that we sell businesses. We can't put together business contracts. Usually when we sell a business, an attorney has to get involved to write up that contract as well. So some brokers like to stay away from it. However, what's on the state is that a licensee who engages in the sale, purchase, or leases of businesses must have an active real estate license, not have a business broker license, okay? That's just the nickname. Now, I just used the word licensee, right? So let's talk about the different categories of real estate licenses. Sales, let me ask you guys, just to make sure you're in the right place, right? Are you guys here to get a realtor license? Use the chat bar or mute yourself. You guys are here to get a realtor license.
Yes.
Yeah?
Yes.
No. No.
No, the sales
Sales
associate.
associate's license.
Thank you. That's on the state, by the way. All right. Yes, you're here to get a sales associate license. You're not here to get a realtor license. Okay. So this is the time to slip up, and I truly believe that I teach by tripping you guys up, because if I trip you up today, you ain't gonna trip up when you take the state exam. You're gonna remember that question. Okay. So please do not stop that from engaging when I ask. Today is the day to get the wrong answers. I don't think anybody in here knows each other except for my students that took the class together. And then again, all you guys did was meet each other for a week on Zoom. Or for my 6-week students, you've been together for 6 weeks on Zoom. Nobody's going to judge anybody here. I sure as hell am not. Here's the time to get it wrong, right? So yes, you are not getting a realtor license. How do you become a realtor? You join the National Association of Realtors. It's a trade organization. It happens to be the largest in the world. Real estate licensee. So let's go back to the different license categories, and this pops up in chapter 2 or 3. Sales associate. Yes, you're in the right place. Then you have a broker associate who is broker capable, but works for another broker. And when I use the term licensee, it encompasses any 3 of those. So a licensee can sell businesses, right? But of course, a licensee, if they're an associate, whether sales or broker, must get the broker's blessing. Okay. So when I use the word licensee, I'm talking about anybody with a real estate license, whether it's an associate or the actual broker, but you still have to fall back to the fact that if that person's an associate, the broker must give the blessing. Property management, hitting hard on the state exam. Who does the property manager represent, guys?
Owner.
The landlord, the owner.
Most correctly, the absentee owner, but you're all in the right arena. There's a question on the state exam that says, what is not one of the things that the property manager does, and that is represent the tenant. They market the property, they represent the absentee owner, they set up leases, but they do not represent the interest of the tenant whatsoever. And that's on the state exam. Now, let me ask you one more question. Why has there been a growth in property management? Why has property management become so popular lately?
Owner investors.
Because of a growth in absentee owners. Thanks.
Absentee owners.
Because of the growth in absentee owners. Okay. How many of you that have taken the state online so far feel like I'm hitting this nail right on the head with these questions that you've seen?
Yes.
All right, bingo. So follow with me, trust me. If I skip it, it's not on there. I know what's on there. So growth in property management due to an increase in absentee owners. Let's talk about appraisals, because I really don't get into chapter 16 too much, okay, in this particular course. Appraisals. A licensee can do an appraisal. Last time I'm going to say this, with the blessing of the broker, of course, right? Now, in order for a licensee to do an appraisal, there must be certain things present or not, right? Like the first one, and the one that they harp on the most, is that it can't be for a federally related transaction, right? You probably learned on the course level, federally related, Fannie Mae, Freddie Mac, any FDIC lender, they're talking about mortgages. But of course, you take the state, and it's not about Fannie Mae and Freddie Mac. They ask you the following question. Well, we can legally sell businesses, right, if our broker lets us. So we can appraise businesses. And they ask you the following. Can a licensee do an appraisal for a business that is publicly traded? And this is not in the book, but they're going to expect you to know that the Securities Exchange Commission would now be involved because of the fact that businesses that publicly trade are governed under the Securities Exchange Commission. Okay? So it can't be federally related. Look out for the publicly traded business. Number 2, you must follow USPAP guidelines. The only thing you really want to know about USPAP guidelines is that you can't charge based on the outcome of the report, based on what the final value is, but you can charged based on the difficulty of the report. So certainly it's going to be more difficult for me to go do an appraisal on a waterfront mansion in Coral Gables by the sea and to measure out an 11,000 square foot home that's on the bay than it is to do a cookie cutter, townhome out in the Kendall area for those of you that are in Miami. But so you understand the difference. Yes, I'm going to charge more because it's going to be more difficult to find waterfront comparables. It's going to take me a lot longer to take pictures of a 10,000 square foot home. But it's not because that home is going to come in at $20 million and the townhome is going to come in at $300,000. It's because of the difficulty. Okay, but you can never tie it into the value. Then I want you to know that you can never say that you are a licensed appraiser. You're a licensee doing an appraisal. Okay. Quick question: is there a limit to how much the appraiser can charge? As far as I'm concerned, there is not a limit to how much an appraiser can charge for an appraisal. Is there a limit to how much a broker can charge a seller to sell their home? No, there isn't. Brokers, this is on the state exam too, are the ones that set commissions. Brokers can't get with other brokers to set commissions. But as far as I know, there is no maximum that appraiser is limited to. Now, CMA and BPOs, these are tools most commonly used. Comparative market analysis. Once you're in the business, you're going to be doing these like crazy. You don't have to comply with USPAP. You can charge for these. Good luck charging for them. This is usually what we do for our sellers and buyers when arriving at the valuation of a property, right? Maybe for the seller at a listing price and for a buyer at an offering price. You can charge. These are very informal because you don't have to follow USPAP. Now, a broker price opinion, we do these for asset management companies or relocation companies, usually asset management company in distressed sales situation, right? Where the property's hitting foreclosure. Sales associates may complete these. They're called broker price opinions, but we can do them like we can do everything else under the direction and control of our brokers, right? And again, CMAs and BPOs, I want you to know, no USPAP, appraiser, you must use USPAP. Financing we'll cover a little later, but I want to get, this will come up again in chapter 2, but before I forget, on the state exam, there's a question that says, a judge appoints the owner of a gas station who does not have a real estate license, he just owns a gas station, to do an appraisal for another gas station. Can he do that?
Yes.
Listen, if a judge tells you to do something, you better do it, because what happens if you don't follow judge's orders? You can go to jail. Okay? The judge may have gone rogue, right? He's interpreting 475 incorrectly, and that's up to take it to higher judicial courts, like, district courts of appeals, if somebody has a problem with it. But judges interpret law, and they can interpret it pretty much how they like. And I'm not getting into politics here or whether I am for or against it, but let's go to things like marriage equality. I'm going to tell you I believe in that. Let's go to things like abortion, right? Where did they pull this out? Usually they use the 14th Amendment, which is very vague, which was post-Civil War. And they created and legalized these things, which, again, I don't want to get involved in politics, but there is no specific wording for it. Judges interpret law how they like. And these made it all the way to the top of the totem pole as far as the judicial branch goes. And they are the law of the land. Plat map. I don't know, this word seems to come up in this book I don't know how many times. And this is always on the state exam. Where there is platted maps, or where plat maps are recorded, it is a lot and block description out of chapter 10. There's 3 types of survey methods in chapter 10. The only question you're going to get about lot and block is about the plat map. We'll talk about some of this other stuff. Here's your realtor. How do you become a realtor? You join NAR. NAR handles ethics. Okay. Any questions on chapter 1 so far? Or not so far, we're done with it, but I'm going to pop up a question from these red slides. Some of you are going to be getting them that purchased it with, if you bought it through my website, for the additional 10. Some of you, I emailed to you it already. I had it at one point where it downloaded. I have to figure out why it stopped doing that.
Can you hear me?
I can hear you. What's up,
Okay.
Ron?
Flat map. You kind of went over it pretty quick.
Yeah.
It's on. It's on or it's not on?
What's on?
Flat map's on the test.
Yeah, it is. Plat map equals lot and block. You can count on seeing that every time, pretty much. It's one of those. It's one of those questions.
What's the ratio of those questions to the overall test?
Well, I can't give you a ratio. They have a pool of questions, and they
It's
pull
big.
out.
It's not big.
It's prevalent. It's prevalent.
Okay.
It's prevalent. Now, number 3 here, they dumbed it down a little bit for the state exam, but I want you to read it this way. Go ahead and read number 3 and type in the chat bar the letter that you think is the answer. Give you guys about 4 minutes. My students who are already taken and have this red slides with the answers, please refrain. Let the ones that don't. James, we'll talk a little bit about chapter 10. Yeah, I'll go into there. It'll be quick, but we'll talk about meets and bounds. So go ahead, type in the chat bar. What do you think number 3 is? Give you guys a few minutes. All right, guys, I've kind of seen a bulk of it. It started off nice, and then it didn't, and then it ended nice. Guys, what am I testing you on here? The broker owns everything. Christina's a sales associate. She cannot charge for BPOs. So those that put B, somebody put C, that's like in left field. This pretty much is just testing you on the fact that a sales associate can't collect a dime, guys. She's a sales associate. Ethical egoism, once again. All right, so let's jump into chapter 2. 2, I do it 3. Okay, that should actually be one long chapter. And we'll talk about a few things in 3. As not a few things in 3. I pretty much cover most of it. Chapter 2 is 6% of the state exam. Chapter 3 is 2%.
What does
Go ahead.
what
You were
what
somebody
what,
was.
what
was
does
go ahead.
NAR stand for again?
The National Association of Realtors. When you join the National Association of Realtors, really when you join the local board, right? Like I'm a member of Miami. Miami goes all the way to Port St. Lucie. I know there's a few in between from here to there. When you join the local, you also join the state, which is FAR. FAR we'll talk about when we talk about the forms. They're called the FAR bar forms because the forms that we use for contracts are whatchamacallit, put together by the Florida Association of Realtors in conjunction with the attorneys bar. And then you would also join the national. So you join local, state, national. So chapter 2, this is about the laws affecting real estate. And I'm going to give you guys a basic rundown on the 3 branches of government used in our country because you're going to need to know that for state purposes because these powers are granted to those that govern these licenses. So chapter 20 of the Florida statute, which is the organizational branch of Florida government, which means it's the executive branch. You guys learned, right, on a course level that who appoints the members of FREC and who appoints the secretary of the DBPR? Unmute yourselves.
Governor.
Right, and then you take the test and the governor is not there. Why? Because it's replaced by chapter 20. The governor is the leader of the executive branch of Florida, right? So therefore, chapter 20, the executive branch appoints the members of FREC and the secretary of the DBPR subject to state Senate confirmation. Now, the governor gives FREC, the Florida Real Estate Commission, which is in charge with certain powers. They're granted full executive powers, meaning they have the full right to enforce real estate license law in Florida. However, the 2 other branches of power in government, they are given, but on a quasi basis. What does quasi mean to you guys?
Partial.
Partial, almost, right? So they're granted quasi-legislative powers. Why? Because chapter 475 below on the screen, that's law. FREC does not pass law. Who passes law in the state of Florida? Florida Congress, a bicameral body just like our Congress on a national or a federal level, right? So chapter 475 is law. FREC does not pass law. This is on the state. What power grants FREC the ability to pass and create rules? Their rules are 61J2, and that is their quasi-legislative powers. All right, so their quasi-legislative powers allow them to pass and create rules. They do not pass law. And then lastly, they're given quasi-judicial powers. Why is it quasi? Because they cannot put you in prison. And that pops up quite a bit. That's one that when it's an option and for whatever reason it's an option a bunch of times, disregard it. FREC cannot put you in prison. Now, FREC has the responsibility to refer you to the state attorney's office for criminal prosecution. right? Now, their quasi-judicial powers grants them the ability to hand down administrative penalties. Okay, administrative penalties are limited to $5,000 per count on a fine if you're found guilty, suspension up to 10 years, revocation, which is permanent, their power to approve or deny applications, etc. Now, I want to revert back to their quasi-legislative powers and their rules, which are 61J2, and tie it into 475. 61J2 rules. Usually, no, not usually, but for the most part, there is no victim or potential victim. What are some rules? Mutual recognition, which we're going to talk about in a minute. Your licensing requirements, right? Your 10 days to update your email or mailing address, things along those lines. And nowadays it's email address, guys. If you get a letter from FREC, you're in a world of shit. They don't send snail mail anymore. Things like that. And we're going to practice that, and we're going to point out, is this a violation of 61J2 or is it a violation of 475? For example, the sales associate one, that's on the state exam, and the correct answer there is not that Christina cannot collect the fee. The correct answer now on the dumbed down version, which is online, says the sales associate violated chapter 475. The broker didn't violate 475 because that's going to be an option. Why didn't the broker, even though the broker can be held responsible for the acts of the licensee, I think in the case, Christina was pretty much stealing from the broker, right? Because usually the broker is going to get his hands on some of her work, right? Because he's using her license. He was victimized by it, so therefore he didn't violate. She violated 475. Now let's talk about Chapter 475 of the Florida statutes, and really we're going to talk about Part 1, real estate brokerage. This is real estate license law in Florida. What happens when you violate the law, guys?
Punishment.
You get fined.
Clink, clink.
Some sort of criminal punishment. I mean, it doesn't necessarily have to be jail time. You can get fined, but yeah, it's going to be some sort of a penalty, right? I want you to know that all but four violations of Chapter 475 are second-degree misdemeanors. 60 days, $500 fine. Okay? So, for example, giving an opinion of title is a popular one now. That's a violation of 475. That's a second-degree misdemeanor. Working for two different brokers, working for a broker and an owner-developer. You can you guys, once you get your license, let me ask you guys a question. Can you work for any broker? Once you get your license, can you work for any broker? Come on, Mary Jane. I taught you all of this. Let the other ones. Yes, you can only work for one. Some of you were probably thinking, yeah, I can work for any broker. I've gotten, I don't know how many damn postcards and how many phone calls since I became exam eligible, right? So you feel like you can just go work for anybody. But that's a play on words. If you tell me, yeah, that you can work for any broker, you're telling me you can work for more than one at a time. So look out for that play on words on the state exam. That's a violation of 475. Now, again, victim or potential victim. The other four that are not second-degree misdemeanors, there's one that's a first-degree misdemeanor, and they love to ask this one on the state. And that is providing false rental information for a fee. You put together a bogus list, you sell it, you can be charged with a first-degree misdemeanor. 1 year, 1,000. Then there are three of them that are third-degree felonies. $5,000 fine, 5 years in prison. And those happen to be A, operating without a license. And they're not going to tell you that there was this crazy guy that decided to go out and sell real estate because he couldn't pass the exam. No, it's going to be a sales associate who decides to open up an office, right? That's operating without a license, or somebody that didn't do their continuing education. They're not going to make it that straight to the point. The other two are theft of a state exam and falsifying an application to become licensed. All third-degree felonies. Okay? So as we go through some of this, I'll point out 475 versus 61J2, which is here. Now, 455 is also on the state exam, and I'll talk about who the DBPR is. The DBPR is the Department of Business and Professional Regulations, right? They are charged with handling a multitude of professions in the state of Florida. Not all of them, but quite a bit. Anywhere from real estate, obviously, which happens to be their largest. So real estate has its own division, to electricians, accountants, paramutual, which are blackjack dealers, poker dealers, whatever. They handle a multitude of professions in Florida. What gives them that right? Chapter 455. Okay, that's on the state exam. You want to know that Chapter 455 grants DBPR the power to control, to uphold, to govern these licenses, right? And that's because their secretary of the DBPR is appointed by the governor, or possibly Chapter 20. You'll see in lieu of the word governor. That's what's my understanding is on the online court, the online state now, is the secretary of the DBPR appointed by Chapter 20, subject to state Senate confirmation. Chapter 120, don't worry about it. 61J2, we know our FREC rules. We talked about this. Here is, I talked about, you can be employed by and work under the direction and control of a real estate broker or an owner developer. During lunch, I'm going to send you a link to a blog that I wrote that talks about model verbs, which is how they trick you on the state exam. Some of you may have this down packed. I'm smart, but they're tricking you with the must, the may, the can, the and, ors, things along those lines. Okay, so in this case, you can work for a real estate broker or an owner developer. You cannot work for a real estate broker and or an owner developer, because if you chose and or, which we use very loose in conversation, you're telling me you can work for both at the same time. Any questions on that?
No.
All right, perfect. I'm not going over the application. They do not ask on the application on the state exam. But you want to know reciprocity. They do like to ask about this. These are the only people that get reciprocity. Others get mutual recognition, which we're going to jump into here next. And reciprocity means if you are licensed somewhere else, you automatically become licensed here. And we only offer that to U.S. military members or their spouses, whether active or former. So if they have a license in any other of the 49 states or jurisdictions or territories, better said, all they have to do is submit an application, they get a license. They don't have to do the 63 hours, etc. Okay. Now,
Do they have to do the post license?
I don't believe they do have to do the post license. They would have to do the 14 hours continuing education.
Wait, I'm sorry. This is only if they're licensed in another state already, right? Or they can just get it.
Yeah, they have to have a license in another state.
Okay. Thanks.
Yeah. All right, so Florida resident defined, and I want to talk about Florida resident defined because, sorry guys, I should put this on mute. Florida resident defined is 4 months. Why do you need to know this? Because we do not give mutual recognition to Florida residents. We have mutual recognition with 9 states. You do not need to memorize the 9 states, right? but I'll give you a few: Georgia, Alabama, Arkansas, Oklahoma. And I don't know, when I hear those states, I think of, I don't know, maybe states that are not very high on education per se. So guess what? Just like those states, we have mutual recognition with them, is because they're at the bottom of the totem pole when it comes to educational requirements. You want to get a real estate license in California or even Texas, you are going to be doing, in California, it's almost like an AA. In Texas, it's like 200 and something hours, right? So we don't have mutual recognition with them because they don't want mutual recognition with us. Our requirements are way below theirs to become licensed. Here's the thing is, the state exam is hard, and I feel like 63 hours is not enough, and I think you guys feel like 63 hours is not enough because you're here with me today, right? Now, if they're coming from one of those states, don't worry about how it works when we go there. Massachusetts is, we don't have mutual recognition with them. The only state we have mutual recognition in the Northeast is Connecticut. So you want to concentrate on when they come to us. First, they can't be a resident. Second, they have to provide the history of their licensure in one of those 9 states. And then all they have to do is take a 40-question Florida-based law exam, and they will obtain a license. I'll tell you, though, we have mutual recognition with Georgia. If you wanted a license in Georgia, you apply, they give it to you. But I'm just giving you that for your knowledge, in case you're in Jacksonville or you're in North Florida and you somehow want a Georgia license, all you got to do is apply and get one. They don't make you even take the 40-question law exam. But Florida, for Florida state exam, no, can't be a resident, meaning they can't be here for more than 4 months. Most of these people do it while they're in the other state. A grand majority of people that I'm running into that are getting mutual recognition are coming from Illinois. We just got mutual recognition with them a few years back. A lot of Chicago brokers are wanting to get Florida licenses. And then again, mutual recognition is not reciprocity. All right, so summary of educational exemptions. So I'm going to talk about the courses. I'm going to talk about the renewal dates at this time now. Some of it pops up in chapter 3. Daniela, that must be you. Everybody can hear me fine? Daniela's saying that she can't. Yeah, I figured sometimes it's on their end. All right, so we'll continue. Hopefully you can fix that on your end. Remember, I am recording. So you guys took the 63-hour course, right? Unless there's an attorney in the room, and I usually get 1 or 2 who didn't, and they're just taking this for reinforcement, right? You take the 63 hours, you take the state exam, you pass. We're going to say everybody here is going to go and take the online course. You know, you can get an appointment the very next day. You're going to get licensed, we'll say February 10th. When do you have to renew your license by? Can anybody help me? Just kind of give me the
2 years?
2 years, but can you give me a specific date?
March or September. So you'd probably get, would you have to renew in September since it's before?
September 23.
All right, so February 10th, this is how I do it. You go forward 2 years. February 10th, 2021, you go to February 10th, 2023. Then you go backwards to the closest renewal date. You never go forward because it can't be more than 2 years. So in this case, this person would have to renew their license by what? September 30th, 2022. Does that make sense? February 10th, 2021. Go forward 2 years to February 10th, 2023. You're not going to go forward to March 31st, 2023, because now you're going past 2 years. So you got to go backwards, and you're going to go all the way to September 30th, 2022. By that date, you have to do what? Your 45-hour continuing education course. Failure to do so would put your license null and void, like it never existed. They give you a question on the state exam that says, somebody had a real estate license, they lost it, it went null and void due to the 45 hours, and they want to get back into the real estate business. What should they do in order to get back in the real estate business? A says they need to go back to the class, and well, again, ethical egoism, right? You're like, damn, that's what I'm dreading, man. I gotta take the 63-hour course again with Jose, blah blah blah. He makes it so damn hard, and I do because you guys pass the state exam. But that's not the correct answer. Somewhere down the line, it says you must requalify for licensure. What does that mean? That means you got to send the state application again. You got to do your fingerprints again. You not only have to take the course again, you got to take the state exam again. You got to do it all over again. And Michelle, I'm sorry. I'm talking about the 45 hours. This is being recorded. Just remember to go to this part where you weren't hearing. I don't think it's fair for everybody else for me to repeat this. So September 30th, 2023, you did your 45 hours and you didn't go null and void because you're going to go do your 45 hours ASAP. 75% of the 45 hours is what's on the 63 hours. So it's might as well get it out of the way before you start getting really busy selling homes, right? Now, by September 30th, 2025, you have to do a 14-hour continuing education course. If you don't do it by September 30th, 2025, well, the good news is you don't lose it, but if you continue to practice real estate, you are going to be committing a third-degree felony. So now, from October 1st, 2025 to September 30th, 2026, all you have to do is you're going to be in involuntary inactive status, and all you have to do is do the 14 hours and pay them a late fee, and you reactivate your license. Now, from October 1st, 2026 to September 30th, 2027, you have to do a 28-hour reactivation course. So now you got to do double and pay a late fee. You can imagine what happens on October 1st, 2027, right? Your license goes null and void. So on subsequent renewals, meaning not your first, they love to use that word subsequent. If you do not do your educational requirements, which is the 14 hours, your license falls to involuntary inactive. The longest period that your license can stay involuntary inactive due to educational defaults is 2 years. Now, your license can be involuntary inactive as long as you want, as long as you're doing your educational requirements, and it falls to involuntary inactive for one other reason. Can anybody tell me why you would be involuntary inactive outside of not doing your educational requirements?
Broker loses their license.
Retired.
You don't have a broker, period. Broker, you don't have a broker, broker loses license, a multitude of reasons why you can fall to involuntary inactive status when it comes to the broker. Now, if the broker dies, they give 14 days to replace the broker. Okay. All right. So now let's go to the 4-year degree real quick. Everybody has to take the state exam except for the military reciprocity, right? If you have a 4-year degree in real estate, the only course you have to take is, yeah, broker quits. For whatever, no, that, yeah, perfect. You don't have a broker for whatever reason. Somebody with a 4-year degree in real estate, and like, it has to be in real estate, does not have to do any of the courses except for the 14 hours. Okay, but they must pass the state exams, right? The sales associate and the brokers. Somebody who is a active member with the Florida Bar, an attorney, does not have to take this course, the 63-hour course. Well, they usually end up having to take this particular Cram course to get a refresher from what they learned in law school. And they don't have to do the continuing education, the 14 hours, because they do their own continuing education for the bar. okay? But they're not exempt from the post-licensing status. Now, you see here too, FREC Course 2. What's FREC Course 2? FREC Course 2 is if you ever want to become a broker, right? In order to become a broker, you need 2 years experience within the last 5 years, right? Then you have to take a FREC Course 2, which is a 72-hour course. That course is much more advanced than this one, but there's some stuff that's rather repetitive from here as well. They will also grant you your experience as a sales associate in any other state or nation, and when they say nation, it's Canada. There's a question on the state exam that says the following. What a sales associate wants to get their broker's license as quickly as possible. What is the first thing they must, and I'm using a modal verb, must do? Anybody seen that one and know what the correct answer is? Let's go, chime in, guys. Unmute yourselves. Chat bar. What is the first thing they must do?
Complete their post-license class.
Perfect, thank you. That is the first thing that they must do. If they didn't do their 45 hours, they haven't gotten to 2 years. So look out for that, guys, because that's somewhere hidden down the line. You guys are going to harp on the 2 years in your head, right? And 2 years is you're in a hurry because maybe you're smart. But this test is meant to be taken slowly, meant to be analyzed. Those musts, mays, cans, make sure to pay attention to them.
I have a quick question. So is there like a certain amount of requirements of transactions that you need to complete in order to get the broker's license?
There is not.
There's not, okay.
2 years experience, and simply you could have never have sold a home.
Okay, thank you.
They used to actually, it'll be 20 years for me. I've been in the business since I was 21 this June. When I got my instructor's license way back when, I had to have a certain amount of transaction. They since have waived that, even for instructors.
Yeah. I'm from New York City and they require it still.
They
so
require.
Yeah.
Yeah, if you're from New York and you've had a license in New York, I know Ron is on here. He's from New York. Chapter 4 is going to drive you nuts because, yeah, authorized brokerage relationships, and only because I think New York is out of their mind.
Really? Yeah.
Because they allow you to represent as a fiduciary both parties to a transaction, and to me that's absurd. How can
I
you
noticed a big difference.
How can you really represent wholeheartedly the interest of the buyer and the seller in the same transaction? Nevada is the same. Yeah, Chris, there's a lot of states out there that are the same. When it comes to like, I just, fiduciaries, you're going to represent this person, in a, relationship of trust and confidence, and you're going to, basically represent them as you would represent yourself. How can you do that for both parties in one transaction is beyond me.
That was the most difficult transaction of my career in Nevada, was having a transaction of dual representation. I will never do that again. It sucked.
Yeah.
I'd like to some clarification real quick.
Yeah,
So,
sure.
To become a broker, the first thing you need to do is a 45-hour, right?
Yep, you have to do. You have to do.
Sorry.
Yeah, it would be what must you do first, right? So before 2 years, you have to do it.
Okay.
Right. So it's a play on words, and I'm going to practice questions with you, right? Okay. All right, guys. So let's keep rolling down the line here. Post-licensing, we talked about this. I don't necessarily use the slides. My students know how I complain about the order. This book sucks, right? So broker requirements, here it is. That's what's on the state. Must complete first, right? And then any of these two, you could do the 72 hours before you get the 2 years. So as soon as you get the 2 years, you send the application. That's fine. pass the state exam, and then you have to do another broker poll. So you're going to get a whole new anniversary, right? And then let's practice the anniversary once again. Ron, broker versus broker associate. A broker associate is just a broker capable that works for another broker. I am the broker of the office where I'm at now. I've been brokers before, and in between, I've been a broker associate for other brokers. So it's just, I can open up my own office tomorrow if I'm broker associate, but I choose to work for another broker. So let's practice this. Now you get your broker's license in November 10th of 2024, okay? When must you take your 60-hour post licensing for your brokers? November 10, 2024. Again, I go forward 2 years, November 10, 2026. And then I go back. Well, what's the closest one back? September 30th, 2026. Make sense? Everybody good with those? That pops up in chapter 3. 2026. Thanks, Michelle. What happens if you don't do your broker post licensing? Well, the good news is you don't get left out of the business, but you will get your sales associate license back once you complete the 14 hours. All right, here's the 2 years experience within the last 5 years. It can come working for a Florida broker or a broker in another state. So they won't penalize you. If you had 2 years in New York within the last 5 years, you can just jump into getting your broker's license, right? But you would have to take the 72-hour course. We don't have mutual recognition, right, with New York, for example. Or if you were a broker in another state or nation and you don't have mutual recognition, you could just jump into taking the 72-hour course. Prima facie evidence. This is on the state exam. Prima facie evidence is evidence that's good on its face to establish a fact. Is prima facie evidence always good? That's on the state. No, it is not always good. It can be refuted with evidence to the contrary. And I talk about philosophy a lot. It's a passion. Philosophical arguments are based on prima facie evidence. And we can sit here and have one, and you can refute my evidence, right? Now, the way I want you to know this is your real estate license is prima facie evidence that you have, that you are licensed. But I can refute it. For example, I know that your license got suspended for whatever reason, and you show me your real estate license that you're still carrying around. I can refute it with, yeah, it's no good. You're out of the game for 3 months. You know what I mean? So it can be refuted. Driver's license, right? Bill shows me his driver's license. Great. I don't know how you still have it in your possession. You haven't paid your parking ticket since 1985. I'm refuting the evidence. So it is not always good. All right. So these are the real estate services that require a license unless specifically exempt, which we'll discuss in a minute, that you must have a real estate license to do for compensation. Advertise, buy, appraise, rent, sell, auction, lease, and exchange. I will tell you right now on the state exam, auction is one of those. If you have a real estate license, you do not need an auctioneer license. If you want to auction off estates, yes, you need an auctioneer license, but not to auction off real estate. A real estate license will suffice. All right, I'm going to give you a scenario, and my students try to hold back, and let's see what they have to say. And Mary and Sarah are the best of friends. They've lived next door to each other for the last 45 years. And Mary has decided to move out of town because her husband just passed away to be closer to her grandkids, per se. Since Mary's leaving, soon, she's put up her house for sale by owner, and Sarah has been spending a lot of time with her, before her dear old friend leaves town. So Sarah hung out when Mary did an open house last Saturday, and they got a lot of traffic. So Sarah showed the couple Mary's home, and even after showing, helped her negotiate an offer for Mary. Is there a violation of Florida real estate license law? Come on, a few of you. Type in, unmute yourself. I got a yes, no, yes, not order. She's not a sales associate. Julie, thank you. That's exactly why there is no violation. If you want to be the Mother Teresa of real estate and you want to do this for free to help your friends, family, strangers, whatever your passion may be, you don't need a real estate license as long as you're not collecting a penny. But here's the definition of compensation, right? Anything of value paid or promised to be paid. So if you give somebody a bottle of Blue Label, right? If you promise somebody, for example, Mary would have told Sarah, hey, help me out this Saturday, and if we sell the house, we'll go over to the Seminole Hard Rock Casino. I'll give you a few $100s to put in the slot machine, and I'll buy you dinner. That was a violation of law. What can you give somebody, and this is on the state, for referring you business that doesn't have a license? Anybody know what the answer is on the state?
Nothing.
No, the correct answer is a thank you letter. I guess a thank you letter is nothing, right? It's worthless. That's all you can give is a thank you letter. Hey, thank you for referring me business. We're talking about for the state exam, right? In the real world, if my barber were to refer me somebody, I know he likes some fine scotch. Might just give him a nice bottle of fine scotch because he cut me up real nice that day. Give me a nice fade. Let me check the chat. $50 for rental referral from a property manager or leasing office. Christopher, that's not necessarily correct there. It's no longer really on the state, so I don't talk about it. But since you're asking, if you live in the apartment complex and you refer a tenant, the max they can give you is $50. But you have to live there, not be an unlicensed person that doesn't live there. If you own the property, guys, you don't need a license to sell it. Salaried employees, this is important. If you are a salaried employee and you work directly for the owner, like many property managers do, you do not need a real estate license, right? Here's the thing is, they give you an example of a salaried employee who receives a Christmas bonus. Christmas bonus is now transactional, right? That Christmas bonus can depend on, hey, you had a great year. Here you go, a nice fat Christmas bonus. There's another one that says that this person works strictly on salary and they get no commission, no bonus. They only work on salary, but they write leases for 18 months. What's true about that? What's true about that is that you can't write leases for 18 months. We can't even write leases for 18 months. So it would be a violation of 475. And here is the court appointed in, go ahead.
Quick question. I asked in the chat when we were talking about a bar sale and for lease, the lease has to be under 12 months.
Yeah, 365 days is the max. And chapter 475, again, pertains to not only licensees, but the public, and in particular, a salaried employee working for a property manager. As long as she's paid a salary and all that, they paint it very pretty, but then they say that she, puts together leases for 18 months. Only an attorney or the property owner themselves can put leases together for more than 365 days. Here's your court-appointed individual. If a judge says do it, do it. There's an example like the one I gave you of Mary and Sarah, and somehow Mary dies, actually. I guess her husband died, and she dies, in the process of trying to sell her home. A judge appoints the best friend, Sarah, to sell it, make a commission, and give the rest of the money to the kids. All right? Anytime a court is an option, who can remove a deed restriction? Who can remove an easement? But judges can do and interpret law however they please. So that's kind of a no-brainer, right? A judge can go rogue. That's fine. A judge can, not be interpreting law property, and they can still do it, right? Only if it works its way up the courts can it be reversed. So if ever there's an option with courts and you're in doubt, or judge, pick that. A court can remove an easement. A court can remove a deed restriction. In the real world, more than likely they won't remove deed restrictions. More than likely, easements 50-50, depending on the easements. More than likely they will enforce easements. And we'll talk about easements a little later. Now, I want to talk about two things that are left out of chapter 3 that I didn't tie into chapter 2, and we'll take a quick 7-8 minute break. And then we'll get into chapter 4, which you guys love. I don't use the slides for 4. Multiple licenses versus group licenses. Multiple licenses a broker can have. What does that mean? He owns ABC Realty and XYZ Realty. He owns 2 different brokerages completely. That's multiple licenses. Most brokers have one brokerage, and then they have branch offices, right? For branding purposes, you own ABC Realty. Your main office is in downtown, and then you got a few throughout the suburbs. But you can also own more than one brokerage, okay? And in that case, it is known as multiple licenses. And then the last part of chapter 3 that I want you to know is group licenses. So we learned that a sales associate can work for an owner developer, right? And they can get paid a commission and the whole shebang. But they can only work for one owner developer. And here's the case. Owner developers, if they have multiple projects for asset protection purposes, they usually put each of those projects in different corporations. So let's say, B&B Builders has 3 different projects. One in Homestead called Keys Entry in Homestead. One in Pompano called, Pompano Canal Front Landings, and another one in Tampa. And each of those are under different corporations, but they want the associate to work at all 3. They provide proof that B&B Builder owns and controls, and they're the master umbrella of all of those projects, and they issue a group license. Can anybody tell me who gets the group license?
The agent.
Good, the associate, right? Because the definition of an owner developer is an unlicensed entity that sells, leases, or exchanges its own properties. Therefore, the one that receives the group license is the associate. Good. All right, guys, and that's chapter 2 and 3, really. So let's go ahead and take a quick 7-8 minute break. I'm not going to pause the recording, because then if I forget to unpause it, I will pause it during lunch, though. Let me stop share here, and I'm going to share the whiteboard. I use the whiteboard to go over chapter 4. So I'm going to mute myself. I'm going to kind of walk away. Something came in the chat. Do you send a copy of the PowerPoint? Yeah, everybody will get a copy of the PowerPoint. And those that paid for the red slides, the additional 10 when bought it through my website, I will send those out to those people as well. I'll give you some instructions before the end of today. I want you to email me, because a lot of you, I probably ended up in your spam for whatever reason, right? And then you're texting me, oh, I found it, blah, blah, blah. If you email me and I reply, you're going to get it for sure. So I prefer to do it that way. And that way I don't have to hunt down each email by email. But yeah, I'll send a copy of the PowerPoints. Also, for your patients hanging around, even though we're still going to go to 6, I'm going to send you 20 math problems with video explanations on how I do it. It's part of my 120 question and answer that I have for sale for 30. I'm going to send you the math part of it. Okay. Any questions before I go have a smoke? Can I put my email in the chat? Yes, I'm going to put my email in the chat, guys. But here's the thing is, do not send me an email until we're done today. I get so many darn emails that if you have to leave early, just set a reminder to send me an email to this email address at 6 p.m. Keep in mind, this recording is going to be long. It's going to take a while for Zoom to upload it. Then I upload it to YouTube as an unlisted video. So don't expect to get, a response from my email till late tonight. And if the girlfriend bitches enough and she wants to go somewhere or whatever, it might be the morning. I'm just going to be honest. I'm going to go ahead and hit mute and let's take a quick 7. All right, guys, I'm back. Everybody here, you can hear me?
Yes, I can.
Yes.
Perfect, thank you.
Go.
I can hear you.
Yes.
All right, so let's go ahead and talk about chapter 4. And chapter 4 is authorized brokerage relationships, right? In the state of Florida, the broker has 3 options when it comes to representing the interests of buyers and sellers in residential resale transactions. So once again, the broker has 3 options when it comes to representing the interest of buyers and sellers in residential resale transactions. Okay. The first one is single agent. And I'm going to go from the ones that have the most duties and responsibilities. I'm going to draw a cup here and I'm going to tie these cups in a minute. This cup is full. And there's going to be some triggering terms that are going to prompt you in the question whether, yeah, it's white, but I'm hoping you're seeing things now. So the word client, the word fiduciary, and the word principal. These should all trigger you to know within the question if they're talking about single agency. Now in red, I'm going to put the duties that are important under single agency. And I'm going to write the acronym and I'm going to tell you what it is. COLD. Confidentiality, obedience, loyalty, and disclosure in full. We owe to single agent clients, right? I want you to know that a fiduciary relationship is a relationship of trust and confidence between the principal and the agent. The principal would be the seller or the buyer, and the agent is the broker. The associates are sub-agents of these relationships. And we need to pay attention to this only when, for example, ABC Realty represents both parties. I'm going to put SA here, and I'm just going to draw the glass of water. Everything that's on the left transfers over to the right. I'm a horrible artist, and this whiteboard doesn't make it any better. So if XYZ Realty represent, we'll say here, on the left, we'll put the seller. And here on the right, we'll put the buyer. I can interchange this and it changes nothing. But again, if XYZ Realty represents the buyer and ABC Realty represents the seller, we don't care. We don't pay attention to this. But we pay attention to this when ABC Realty is representing both. No matter if it's ABC Realty Downtown, ABC Realty Kendall, ABC Realty Tampa, ABC Realty Gainesville, if it's within the same brokerage, even if it's 2 different associates, you have to pay attention to this because we default to what we learned the very first thing this morning, that everything belongs to the broker, these relationships, right? Now, the next form of representation is transaction broker. TB. Here, the cup is half full. For you pessimists, it's half empty. I'm going to get to the chat in a minute, guys. I really rather you guys unmute yourselves, but let me see what's coming in here. Do you mind repeating the acronym COLD? Not at all, Gabriel. Confidentiality, obedience, loyalty, and disclosure in full. Thanks, Noah. So yeah, COLD is confidentiality, obedience, loyalty, and disclosure in full. Trust me, I'm going to go over this again and again. We're going to spend some time on this chapter. And we're going to go over real life scenarios because more than likely you took a cheap online course, you read it to yourself, you got no scenarios. Or you took it at the big school and you got very minimal scenarios, nothing like they have on the state. Transaction broker, customer. Most importantly, I want you to know that it is presumed. Now, in red, I want you to know some duties. The duties are going to be limited, and present all offers and counteroffers. We're just going to write present offers. Lastly, we have no brokerage. No, not in green. I want to keep this color coded here. No brokerage. Cup is empty. NB, cup is empty. We owe this person or persons, right? Sellers or buyers in the same transaction. Three things. A, D, D. Account for all funds is A. Deal honestly and fairly. And the one that you really want to know is disclose all known facts that materially affect the value of real property that are not readily observable. What I want you to know that's in red here, it travels upwards. So if we owe ADD to someone we don't represent, we owe it to someone we represent in a limited capacity. And if we owe it to no brokerage and transaction broker, we owe it to somebody that is our client. Here's the thing, guys. We rarely use single agent, but most of you make the mistake out in the real world and you say client this and client that. Now, if you're selling commercial, this doesn't apply. They're your client. Call them what you want to call them. In residential, you represent the seller and the buyer in the same transaction. You call them both clients. You have just created single agency for both, which is illegal in the state of Florida. You could be charged with a second-degree misdemeanor. And what you created there was dual agency, which is illegal. Okay? Now, what I'm going to do is first, before going over some examples, is I'm going to play the matching game. But right before the matching game, I'm going to talk about when do we establish these relationships. Well, transaction broker does not have to be established. Why? Because it is presumed. So just like a question on the state exam is just going to go about giving you a scenario, it's not going to say principal, it's not going to say client, it's not going to say fiduciary, it's not going to say non-representation. It's just going to give you a scenario, and we'll cover that. We'll practice that now. You have to default to the presumption of law that That scenario is a transaction broker scenario. Okay? Now, that form doesn't have to be given. Somebody walks into my office right now, asks me to show them houses, and I pull them up to my desk and I pull the screen so they look at it, and we get on the MLS and I start showing them property. I'm working with them in a transaction broker relationship. I don't say anything, they don't say anything. That's how I'm working, limited in a transaction broker capacity. Okay? Now, single agent and no brokerage must be established with the seller at time or before entering into the listing agreement, with the buyer before showing the property. So those must be established. You must give them the form. They don't have to sign it, but it's a good idea that they do. But you must at least hand them over the form, physically, email it to them, whatever it may be. I would email it to them, text it to them, have proof that you got it to them somehow, right? Now, if at ABC Realty, we'll say Jim represents the seller and Louis represents the buyer. They both work at ABC Realty, right? Jim has a single agent seller. How can Louis represent the buyer? There's only one option. No brokerage. What are we doing here? I'm playing a matching game without overfilling my cups, right? The cups is like the level of what we owe these people. Loyalty, pretty much. The level of what responsibility we have towards them. Now, if one of the agents at ABC represents the seller and the other the buyer, we could do this. Transaction broker, limited for one, limited for the other. 2 half full cups equals 1 full cup. But also, we can be transaction broker for the seller, and we could be no brokerage for the buyer. And we could be no brokerage for both parties. There is nothing in Florida law that mandates that we have to represent the interest of sellers and buyers, but we have to notify them that we don't represent their interest. All we owe them, again, is we have to account for their funds if we're holding their escrow. We have to deal honest and fairly, and we must disclose all known facts that materially affect the value of real property. That is on the state exam quite often. There's a broker that sold the property 4 years ago, and he didn't disclose a leaky roof. The buyer since sold the property for a profit. Is the broker liable? Oh, A says no because the guy made a profit. And you're like, oh, yeah, the guy made a profit. So who cares? And you picked that one, you got it wrong. No, he was liable to disclose it. Okay, we must disclose all known facts to everybody. Once again, the reds go up the ladder. I don't owe cold to transaction broker, but I owe ADD to transaction broker and single agent. I owe present all offers to a single agent and ADD to a single agent. So these things in red, these duties go upwards, not downwards. Everybody good with that explanation? Now I'm going to go ahead and give you a few of my own examples. We'll go into the slides for a few things that I missed here. That is correct, no. All known facts about the property. What is not a fact is anything that has to do with the occupants. The occupants, there was a murder, suicide, AIDS, whatever it may be, those are not material facts. So I go on a listing appointment. In case this is jargon for you, it's an appointment where I'm going to go be sitting with the seller to convince the seller to choose me to represent him in the sale of his home. Okay. And as I'm going through my listing presentation, he's like, Jose, man, you got the experience, you got a great marketing plan. I want to list with you, but only if you agree to represent me in a single agent capacity. We'll say that Jim, the seller, is an attorney. He knows what he's talking about. So I'm like, sure, Jim, I want your $650,000 listing. I'll go ahead and represent you in single agent capacity. So I email him the form, the single agent form. I have him sign the listing agreement for $650K. I put the house on the market. My sign gets there a few short days later, and a buyer calls me. I tell the buyer, meet me at the property, this evening, and we'll say the buyer is Edwin. So I hand Edwin a no brokerage relationship in the driveway. Before showing him the property, he folds it up, sticks it in his back pocket. Not my problem. I show him the property. And when we're done viewing the property, he tells me, hey, Jose, I'm interested in making an offer. Want to make an offer quick. What do I got to do? I'm like, we could do it now. Well, let's go back to my office. My office is about 25 minutes away from here. Here's the address. Meet me at the office. So I, prepare the offer. I print everything out. I'm pretty old school. And, ask him relevant questions. I usually talk about pricing at the end. And I tell him, all right, so you're offering $650. He says, no, man. He goes, look, the last one sold for $620. I'll offer $625. But you know what, man? I really want the property. But I think I should be able to get it for $625. Why do I got to pay so much more than the last one that sold? But here's the thing. I don't want to lose out on the property. So need be, I'll pay the $650. But I want to start at $625. Okay, Mr. Edwin, put it all together. For $625, I make an appointment to go see John the next day to present him the offer. When I go present that offer to John, what do I tell John about the offer? Unmute yourself. What do I tell John about Edwin's offer?
He offered $625.
Oh, you're breaking out.
Made a counter offer.
I don't know if it's me or you guys.
625.
No, not 625. Jen typed into the chat bar, not that he will take 650, that he will be willing to pay 650 is I think what you meant, right, Jen? So let's go to code, loyalty, disclosure in full. This is my client. He is my principal. I'm in a fiduciary relationship with him. The other guy, I told him I don't represent him. He yapped his mouth. I'm going to tell my seller that this guy wants your house badly. He wants to start at $625, but he's willing to pay $650. That's simple. I tell him everything. Now, I'm going to give you another scenario. And you don't fully represent the other guy. I don't represent the other guy at all, Noah. I told him I do not represent the other guy. I gave him a no brokerage, right? All I owe him is ADD. I have to tell him if something's wrong with John's house. I have to account for all funds. I'm dealing honestly and fairly. I'm not violating that. My loyalty lies with the seller. Now, I'm going to give you another scenario. I go on a listing appointment. We'll say Miguel. And Miguel has a beautiful remodeled house. He thinks it's the best house on the block. He thinks it's the best house in the whole subdivision. And I tell Miguel, hey, listen, man, the last one sold for $275. I think I get you $280, $285, but maybe we're talking over improvement here, man. You really pimped this place out to, really enjoy it. Why are you selling it? Well, I need to move out of town for my job, blah, blah, blah. And he's like, look, I need to get out. I'm motivated, but man, I really think that even though the last one sold for $275, that I can get $299, $900 for it. I'm like, all right, this guy's got motivation. He tells me that it need be, he'd come down. So I go ahead and I list it, and a day later I get a call from Zillow, we'll say, from a buyer. And I tell the buyer, hey, meet me at the property, you know, on Saturday in the morning. I set up everything. I meet the buyer at the property. And I show the property to the buyer. Buyer tells me the same thing. Hey, I'm interested in making an offer on the property. What do I got to do? I'm like, listen, I got some errands to run. How about we meet at my office this afternoon at 3 o'clock? Okay. So the buyer, Jeff, meets me over at the office. And again, I have everything printed out. Last thing I talk about is pricing. And I tell him, hey, he's asking $299.9. You're offering $299.9, right? He's like, no, you crazy? The last one sold for $265. And I'm like, no. The last one sold for $275. Here's proof. Oh, okay. Listen, man, the guy's house is really nice. You know, I don't want to do any work. I want to be in this community. I'll offer him $280 for the property. The most I'll pay is $290. I'm not paying a penny over $290. Okay, but why don't we offer $290 now? No. Let's go ahead and offer $280. Cool. So I put everything together for $280. Next day, I go visit my seller. What do I tell my seller about the offer? I really would love for somebody to unmute themselves.
He'll go to 290.
Anybody got something different?
You tell him the first offer because a single agency hasn't been established.
What am I working as, Noah? That was Noah, right?
Transaction, yes, it's Noah, thank you. A transaction broker.
Exactly. Presumption. I didn't tell you the seller was a client. I didn't tell you the seller I sent him something. I didn't tell you I gave something to the buyer in the driveway. This is the scenarios you're going to see on the state exam, guys. They're just going to go about telling you a story. And you have to presume, unless any of these things in green kick you to prompt you to another relationship, that's transaction broker. In transaction broker, in layman's terms, you don't work to the benefit of one party to the detriment of the other party. Does that make sense? So in this case, I tell the seller, this guy's offering $280. Seller's like, nah, man, there's just no way, you know, like that's $5,000 more. And the last guy, my house is the nicest. I've remodeled everything. I'm like, well, you know, make a counter. So he counters at $295. And the seller tells me that, listen, the cheapest I'll go so I can get the hell out of here now is $290. So now I go back to the buyer. And I tell the buyer, look, he's countering at $295. Oh, but I told you the most I would pay is $290 for it. You know what? I'm going to counter at $285. So I go back to the seller and I show the seller $285. And the seller says, no, I want my $290. Let's counter at $290. Well, I take the $290 back to the buyer and the buyer is like, bingo, okay, I'll take $290. I didn't give away anybody's bottom line. I didn't tell the buyer that the seller needed to move the hell out of town, right? I didn't tell anybody's bottom line. I worked limited to make a deal happen, right? I did give facts. No, the last one didn't sell for $265. It sold for $275. I can give facts. I can suggest based on facts what should be done, but I do not give away relevant information about the buyer or the seller. I work limited and fairly for both, and I must present all offers. Now, I'm going to give you two questions I know are on the state exam from here, and then we'll practice some other questions that are on the state. The first one is your principal tells you to not show the house to people of a certain color. What are you supposed to do? It's a cross-chapter question. There's a lot like that. Now we're talking 4 and 7, right? Principal prompts you to what? Single agent.
Tell your broker.
Well, yeah, you should tell the broker everything. Absolutely. But the correct answer there is something a little different, but you're on the right track, man. You're absolutely on the right.
You inform FREC?
That's actually a federal crime. Here's the thing. Here's the thing is you're stuck between a rock and a hard place because obedience, right? But are you supposed to be obedient to the point that you break the law? No.
No.
So what you do is you withdraw from the
Right.
relationship.
Walk away.
You
Yes.
withdraw from the relationship is the correct answer on the state.
You don't report anything?
Nah, in this case, you wouldn't report because they're your client. You have to be loyal. You owe them confidentiality, almost like an attorney. Well, a single agent, some realtors think they're attorneys, some brokers think they're attorneys, and the closest it gets to being an attorney is when you're in a single agent relationship. So you don't really snitch on this person. You just withdraw and say, hey, as much as, you know, I represent your interests, just like if you told, you know, like if OJ had told, you know, his attorneys he killed Nicole, they couldn't say anything, right? In this case, I withdraw from the relationship because I'm not going to be breaking the law. That's the correct answer there. Do you cancel the listing agreement in writing? Yeah, I would. You know what? If you're in a single agent relationship and you're a seller, start asking your broker to do illegal things, and they're going to have to cancel your listing. Here's another one. You and your best friend are out to lunch, and you just got a new listing, and you start talking about the listing to your best friend, and he's like, "Damn, that's a nice property, man. I'm interested in it. What's the least that they would take?" What are you supposed to respond?
Don't respond.
The
can't
correct
tell them.
the correct answer there is send me an offer and I'll present it. It's transaction broker. Best friend or not, right? It's just you're out to lunch with your best friend. You got a new listing. Your best friend wants information. You're not supposed to give them because you didn't say that your best friend is your client. Blah blah blah. The correct answer to that question is present all offers. So present the offer.
Do you say what they're asking, or you just ask them to make
Oh,
an
yeah.
offer?
Yeah, of course. So, you know, I went over it. I told him what it is, what they're, you know, what I listed it for. And he asked me what's the least that they will take. And my response to that is, hey, present an offer and I'll send it over to them.
Okay.
You know, they try to pry at this like, oh, you're going to have this loyalty to your best friend, or your best friend is all of a sudden going to be your single agent. No, it's not necessarily true. I've used single agent before, and I'm going to tell you why you should use single agent and when, because, right, really we work probably 98% of the time as transaction brokers. A lot of the times, those that forget this end up working in a single agent capacity because they want to start calling their sellers and buyers clients. So they accidentally, or by using words, establish that relationship. But really, there's a form for transaction broker for our own reference, but ultimately, we don't have to give it, and we're working as a transaction broker. But I sold a condo. I put a condo up on the market that was actually under my mom's name. And I was going to benefit from the money coming in from it because it was left through my dad's estate, blah, blah, blah. And a buyer comes off the street, right, with no representation from any other broker. I gave him a no brokerage relationship. I didn't give my mom a single agent to sign because let's say I could have stayed with her as a transaction broker. But I gave this guy a no brokerage relationship. Why? Because if he ever decides to sue for any reason, right, what judge is going to believe that I was limited for my mom, limited for some dude that I don't know? No judge would ever believe that. So if it's close, family, blood, you're better off, you know, giving the other party a no brokerage relationship. In this case with the best friend, they don't say anything that leads you to believe, but I don't know, if I were to be dealing with my best friend, I would probably represent them in a single agent capacity. And if somehow the other party came along unrepresented, I would probably, you know, do the no brokerage. But in this case, for state exam purposes, I'm telling you, that's on the state if you've seen it. Who's seen that one? Who's seen the two that I just went over?
I remember.
Yeah.
All right, perfect. So, you know, for the rest of you haven't taken it yet, trust me, I know what's on there. All right, guys. So remember, this is a recording. You'll get this. I'm going to stop the share, and I'm going to pull up the slides to go over just a few things. And I'm going to give you some easy questions to answer, and then we're going to get into the tough ones. Check. Chapter 4. Just bear with me. Sometimes pulling up the new slides and stuff is not as easy as it seems on. All right. Here it is. All right. So fiduciary relationship. I want you to know there are two things that are opposite of a fiduciary relationship, and that is an arm's length relationship. It is said that buyers and sellers in the course of a real estate transaction are dealing at arm's length, meaning they're dealing in their own best interest. When you represent somebody as a fiduciary relationship, you would be dealing in their best interest. I already mentioned caveat emptor, right? Let the buyer beware, which is opposite of fiduciary, because if I'm representing a buyer in a fiduciary relationship, I'm going to be making them aware of everything, right? We already talked about the principal being either the seller or the buyer, the agent being the broker. Now, there are two subcategories to agent. You want to know what a general agent is and what a special agent is. A general agent does various things for one common outcome. For example, the property manager is a general agent of the absentee owner. They market the property. They put together leases. They handle landlord-tenant relationships. They set up for repairs, all for one goal, to manage the property. A associate is a general agent of a broker because they advertise, buy, appraise, rent, sell, auction, lease, or exchange, right? The 8 services of real estate that require a real estate license when done for compensation. One common outcome, real estate. So general, various things, one common outcome. A special agent does one specific task. For example, my tax guy, he does my taxes. My accountant, that's it. He does one thing, he does my taxes. My insurance agent, I only purchase car insurance. I don't have homeowners insurance because my house is paid and that's a hell of a racket. I'd rather put that money in a savings account. God forbid something happens. My insurance agent just handles my car insurance. That's it. Right? They do one specific task. It is said that a broker is the special agent of a seller who wants to sell their home. They're hired for one specific thing, sell my home. What if the seller hires the broker to sell his home and find them another home? What type of agent would he be? A general. He's doing more than one thing, right? Everybody good with that? The difference between general and special. General, various, but it has to be the same thing, right? Not like nowadays, most real estate agents do credit repair and sell real estate. That would be two different things completely, right? And then specific, one specific task. All right, and then I'm going to run through this. Remember, you guys are sub-agents. The agent is the broker. The presumption. I gave you all of this in my own words.
Quick question.
Go ahead.
The caveat emptor means buyer beware, right?
Let the buyer beware.
Oh,
Correct.
okay.
I want you to know that these disclosures do not apply to non-residential, right? Anything that is not residential resales. I want you to know that also you do not have to give a form if you're doing a bona fide open house. That's on the state. So for example, if I represent the seller as a single agent and I'm doing an open house, every buyer that runs through that door, I don't have to chase them down to give them a no brokerage. You'll find that on the state. Go ahead and read practical example number 1. And tell me what you think.
No brokerage.
Well, it's got to be Amy's broker that has the relationship, right?
Yeah. Always the relationship is with the broker. She can either, no, she must hand them a no brokerage relationship. It's the only option here. If Amy works for XYZ, right? She lists a house and establishes a single agent relationship with the seller. Any buyer that contacts her that wants to view it, she must give them a no brokerage relationship. It is the only option here. No transaction here. You can't be full for one and half for the other, guys. Go back to the cups. And we're going to go back to the cups, actually, as a matter of fact, right now. How many of you did this kind of help, you know, understand this chapter, maybe came in here like really lost with this crap? Because I know this is a little bit convoluted.
That was way better than the book's explanation.
Yeah.
Yeah, it was way better.
All right.
Yeah,
Thanks,
I really like the scenarios.
yeah, the scenarios is where it's at, guys, because then you go take the test and that's what they give you, right? So, you know, I just want to make sure I keep using the cups. Yeah, the cups are helpful. I thought so, right? So there's one more scenario we haven't covered, right? We learned so far that if we have two people that are single agent at the office, right? Like that work at the office, Jim represents the seller as a single agent, and Edwin's got a single agent buyer, and Edwin's buyer becomes interested in Jim's listing. We can't put them together is what we've learned, right? So I'm going to put in red here, can't. But actually, we do have an option if we do this, and I'm going to do it in green. It's called the transition to transaction broker notice. The seller and the buyer both agree to step down one. None of them can agree to go all the way down the ladder. If you're a single agent, you can only come down one. Both agree to transition to transaction broker, and it must be signed. Must, and I'll just put Hancock, right? John Hancock. Must be signed, and then now you could take the buyer. Edwin can take his buyer to Jim's seller. Does that make sense? They must agree and sign to transition to transaction. All right. Let's go back to chapter 5. Only option here. I want you to read example number 2. And I'm not going to give you the correct answer for it now, but tell me what you think it is. I'm not going to give you the correct answer because I got a better one than this that's pretty similar. My students, please.
isn't it that the person doesn't have a single agent? It's not a single agent?
In this case, he's representing a buyer as a transaction broker, and he finds a seller. How can he represent the seller? A few of you nailed this, and I like that. But we're going to hold off. As a matter of fact, I'm going to send those people a message because you actually use the right terminology. Send them a private message. And, well, one of them is my student. And this guy's always on point. The first one to respond to the math questions. No, you know who I'm talking about. And I'm going to go ahead and message one more person. And let's go ahead and move on to practical example number 3. Go ahead and read number 3. And this one, give me the answer and I'll discuss it.
Mm.
All right, I have 13 now. Transition to transaction. Let's get transitions. Must be signed. All right, so you guys remember this one. Cool. All right, so I'm going to stop the share here. And yeah, they work in the same brokerage. Remember, everything belongs to the broker. Because they work in the same broker, it would be dual agency. Even if they worked at separate offices, but it's the same brokerage, right? Branch offices, then they would still have to follow this. So let's go into red slides. And this is where we're going to pretty much do most of chapter 4 in here. I want you to read number 17. Yes, correct, Noah. All right, go ahead and read number 17 and put your answer in the chat. This will give me a moment to run to the bathroom and drink water like crazy. So it's going to take you guys a few minutes. Really read this and decipher it.
Okay. Maybe something's working for. For
I like 26 responses. 27. Let's see what we got here. D, D, A, C. The C's worry me.
I don't know.
It's a commercial transaction. Most of you picked up on that. Perfect. Right? Now, the seventh and eighth word is apartment complex. If I turn that into a condo unit, what would be the correct answer? D. Exactly. No C. No, you never get anything signed prior, guys. That's there really to like throw you off. C is coming out of left field. B, well, we know Fred can't throw you in prison, but they can hand you down an administrative penalty if you did not comply with the requirements of the relationship, right? If this was a residential and the seller was a client, meaning the seller was a single agent, he had to give the buyer no brokerage. But in this case, like most agents have been doing this long enough, he's burnt the hell out and he's spinning his wheels for no good. Because in a apartment complex, commercial, nothing is needed. Caveat emptor. All right. Number 19 is a phenomenal one. It is dumbed down currently on the online exam, but it has this premise behind it.
Can I ask a question about the last one real quick?
Sure, please.
So you said if it was a residential, it would be B, but my question is, it said it was a former client. Does that make him a present client? Could a former client just be a transactional?
Well, because it's an old client of his. Isn't that not what we're talking about, right? The seller is an old client, meaning here's one thing. I'll give you this lecture real quick. I have one agent at my office that I have forced him to establish a single agent relationship with one of his clients. Why? This guy's a retired county employee. He does this for this one guy. He finds this guy houses. They fix them, they flip them. He does 6-7 deals a year, and all 6 or 7 deals are with that same guy. That guy's a client at this point. There's no judge that's ever going to believe that, okay, so over the last 3 years you've been in real estate, and all the deals you've done with this guy Mike, who you help find homes that are cheap for, help him with the contracting, and then help him flip them. Right? That's an old client of this guy. Right? An old client meaning somebody that you've done repeated business with is a single agent. But what Old, new, client is the key word. They love to throw these things in that are relevant, but not necessarily necessary.
Okay.
So let's go back to 19. I'm sure some of you weren't finished reading it. The answer was A to 17, guys. And then I told you to hypothetically change over to a condo, and then that would have been D. All right, I'll give you guys about another 2 minutes to decipher this, and we'll go over it together. All right, guys. So some of you picked A, some of you picked D. The correct answer is D. Why would the buyer have to sign a transition to transaction broker notice? He refused the no brokerage, and this is on the state. A lot of schools don't get into this. They always say, oh, both transition. And that's what I did because I wanted to leave it open-ended because I knew I was going to have you guys read this question. He reluctantly agrees, enthusiastically agrees. Who cares? They love using all these verbs and stupidities that don't make sense. Listen, the guy ultimately says, all right, limited will work for me. Transaction broker. He doesn't have to give him anything. The only one at this point that if that buyer is going to go to that property that needs to do something is the seller. The seller needs to transition to transaction. Does that make sense now? For those of you that picked A, and I understand why you picked A because probably at the course it was always, hey, they both have to come down. But yes, Jenna, the presumption, right? He grabbed the no brokerage and said, no, thank you. I need some representation. Fabian says, well, look, there's a way I can limitedly work for both of you, explains it to him. That's it. In this case, he had to explain it because of the fact that he turned down the no brokerage. And because the seller was a single agent. But since he's going to be a working transaction broker, he doesn't have to sign anything. The only one that has to get anything and sign anything now is going to be the seller.
Quick question.
Go ahead.
So when you do the transition for the seller, when do you have to do that by? Do you have to
before showing the property to the buyer? So now the buyer's there in front of the house. He explains this to him, let's say, and now he's like, "Hey, I'll talk to my seller. I'll get back to you, or wait out here. Let me go inside." However he wants to do it. I probably would have said, "Hey, why don't you go grab something to eat or run an errand? I'll get back to you in 30 minutes or an hour." I wouldn't do it while he's waiting outside, because that's just kind of weird. You don't want to rush the seller through that type of decision. Or can you come back this afternoon or something like that? And now we're just talking stuff that isn't really state related, but I can understand why you asked that, right? The way I would approach it is just kind of deal with the seller and say, "Hey, look, this is what happened. This guy does not," and then it's up to the seller. The seller can say, "Hey, you know what? Have him go find himself another broker then." But then, you're going to explain to him how, that's not necessarily the best thing, because the other broker may take him to another house. All right. I want you guys to do 20 and 21. And then we'll go ahead and take a quick break and jump into chapter 5, which is 12%. We're rocking and rolling at a pretty good pace here. I don't do 6. I do a quick 7, and usually after 7 we do lunch, and that's pretty much leading us right to that 2 o'clock mark. Then after lunch, 8, 9, 11. I do 10 with some math, and mortgages, I tie in some math with the theory of mortgage that you need for the state. So we're at a good pace. Go ahead and do 20, 21, and we'll take a 5 afterwards. Just put in the chat bar, number 20 is this one, number 21 is this one. Give you guys about another 2 to 3 minutes. These are pretty easy reads. All right, cool. I like what I see coming in through the chat bar, right? D. Number 20 is D, and number 21 is D. Anybody object to that? Think something different? Why? I wanna, number 20 is kind of obvious, right? They work for the same brokerage, even though they're in two different locations. A is irrelevant. In this case, D, I think this is a rather easy one. It's just something for you to remember. Now, 21 is a very typical state exam style question. I already mentioned the word and or before. Either that or I have a very savvy, good reading comprehension group here. A is correct. B is correct. C is incorrect because you can't be one and the other. But D is the most correct. Therefore, it is the correct answer. I like the enthusiasm. Any objections to that, guys, before we, let's take a quick, like, 7-minute break. I am going to run to the bathroom and have a smoke. And we'll get started with chapter 5, which is 12%. We'll do 7, take lunch. So I'm just going to go ahead and mute. We'll regroup in about 7, grab some water, whatever you may need. All right, guys, let's rock and roll with chapter 5, very dry, 12% of the state exam. Okay, so high percentage chapter, but it's rather dry. Like I said, it's about the broker. They want you to know about the broker. So I'm going to talk about two things that really don't present itself too clear in the book that are on the state exam. First one is broker tells you to do something unethical and illegal. What should you do? Withdraw, meaning go to another broker and contact the DBPR, turn them in. The other one is the broker's license is suspended. What do you do? Just find another broker. There's no need to contact the DBPR. They already suspended his license. All right, so if you see any of those two, those are the answers for those. So I want you to know that broker must have an office, right? It must be an enclosed room of stationary construction, and they can have offices in another state. Sales associates may not open offices of their own. Again, that's a third-degree felony. Okay, Jenna, broker tells you to do something unethical and illegal and wants you to partake in it. What do you do? The correct answer there would be to withdraw, meaning find another broker and contact the DBPR about his activity. Second answer is a broker's license is suspended, and they give you a bunch of creative shit like you become a broker, or tell them to appeal it. No, just find another broker. Sales associates may not open offices of their own. We talked about that, right? Third-degree felony. Well, you can report a seller, Noah, but the difference is in a single agent relationship, because of confidentiality, it's almost like an attorney-client privilege. You don't. Okay? Branch offices, right? I kind of talked about this. Multiple licenses to different corporations. A branch office is where you have more than one office with the same name. What I want you to know is if you relocate your main office, you just notify them. But if you relocate branch offices, you need to reapply for a new branch office permit. That's on the state. So I have a branch office and I'm in Suite 110 and I moved to Suite 118. I need to reapply for that branch office. Now, the branch office for 110 stays open. If at any point I want to move back to 110, I just notify them. Okay? But branch office permits are not transferable. Main office are. The office sign, they love to ask about this. So here's your office sign, should be on the front door or upon immediately entering into the office, right? This is what must go on the front entrance sign, right? Now, you can put, for example, Suite 110 here in the corner. You could put underneath here the phone number in case somebody shows up and wants to call after hours. These are cans, right? This is the must. Now, you may put the names of associates on the entrance sign. But if you do, you must, and of course I'm stressing on these mays, must, cans, right? Put a line separating on top with the associate's name below. So again, you can put a unit number up here. You can put the phone number on top, right? These are cans. But if you decide, and you may put your associates' names, there must be a line separating this top three, and the associates' names must be below. Okay? Know that for the state exam. Advertising. What is the only thing that has to be in your advertising, guys? There's one thing That has to be. What's the must?
Brokerage name.
The name of the brokerage firm. That's correct. That's the only thing. You can have a billboard on the side of the turnpike, 75, whatever you want, and they can say ABC Realty on it. Not a bright idea unless you live in a one-horse town, they know where to find you. But that's the only thing that must. There's a question on the state exam is, when is it not necessary to put the name of the brokerage firm in advertising? And they give you all kinds of bullshit when the broker puts his home address, blah, blah, blah. The correct answer is never. If you've taken the state, you've seen that one. Never. You can never
Say that
advertise.
again.
The name of the brokerage firm must always go. They give you this answer, so they kind of like, they pry at you, like if there is an exception. They say, what is the exception that the brokerage firm doesn't have to go into the advertising? And you're gonna pick the choice never. There's some options like, oh, when the broker gives his home address or things like that. No, you must always put the name of the brokerage firm. There is no exception to that. Okay, even though they say, when is the exception? Well, the correct answer is never. Great. Well, advertising. Okay, don't worry about team advertising. Blind advertising. Well, blind advertising is when you fail to disclose the name of the brokerage firm, or we're going to talk about now when a sales associate advertises in their name, they must do it a certain way. And if they don't, then it's considered to be blind. So far, we know blind advertising is not disclosing the name of the brokerage firm. Now, when you put your name, right, if you don't do it a certain way, then it could be considered blind. First of all, obviously, we know you're going to put the name of the brokerage firm. You must use your last name as registered with FREC when putting your personal name. And your phone number, if it is not the office number and you're going to be using your cell, your beeper, whatever it is, it must be followed with the words either direct, cell, mobile, beeper. And if anybody has a beeper, that would be funny. I'm kind of kidding. But you must disclose that they're not calling the office, right? If you use the office number doesn't have to be followed by anything. But if you do in fact advertise your name, must be your last name. You can't just say call, Ron. It must be, call Ron Rodriguez. If you use your phone number, again, mobile, direct, cell, etc. Cellular. Most people use direct. You're calling the agent directly. If you fail to not put your last name as registered with FREC or to disclose that it is not the office number by using one of those triggering terms, then it is considered to be blind advertisement as well. Now, false advertising. This is different, right? This is where now you're BSing. Blind is where you are leaving out information. False advertisement can be a number of things, right? For example, I love this one in Miami, ocean view. If you literally have to grab me by the ankles and me dangle off the balcony to catch a peak of the blue and the green, it is not ocean view, okay? Waterfront doesn't mean the lake that forms in the parking lot when it rains heavily, okay? False advertising is where you're BSing it. It could be something like, and you see these on major intersections, 3-2 for 340,000. They use a median price, and then they just put a cell number, and they don't even put a brokerage name. Now we're talking about false and blind, right? False because the 3-2 doesn't really exist. They're casting out. It's a bait and switch. They're using a median price. And then on top of that, they're not even putting the brokerage firm, and they're just putting a cell number. See that all the time. Also, the We Buy Houses Cash guys, most of those guys have a license, and they're really not buying houses cash. What they're doing is trying to get sellers to see if they want to sell or again, that's false advertising, and in many cases, it's blind. Because even if you do buy houses cash, but you work with a broker, you must disclose to the public that you work for a broker.
Good question.
I've had, go ahead.
The phone number. So when an associate wants to put their phone number on an advertisement, that's not a must. That's a can.
It's a can, yeah.
And when do they have to list like what the number is, or they could just put whatever number?
All right. Again, that's a great question. You may put your personal number, but if you do, you must disclose that it is not the office number by using one of those triggering terms. Mobile, cellular, direct, cell.
Got it.
Okay. Again, the one and only thing that must go in your advertising is the name of the brokerage firm. That's it. Telephone solicitation. This seems to be popping up less. Let me just run through it quick. If they're not on the do not call list, you can contact them between 8 a.m. and 9 p.m. to solicit business, right? If they are on the do not call list, you can't call them at all, for the exception of 3 scenarios. The first one, if it's a for sale by owner and you have a bona fide buyer, you can contact them, right? A bona fide buyer. The second one is if you have somebody who you have a established business relationship with, meaning you have sold them a property, you've rented them a property, you can contact them for up to 18 months. And then lastly, the second bullet is the one that has been on the exam before that I know of. And then lastly, somebody who made a business inquiry, meaning they gave you their number through, I don't know, your website, or you captured their number on your caller ID. You can contact that person for up to 3 months after that business inquiry was made. All right, escrow trust. This is definitely where this chapter hits hard. So the escrow account is an account for deposit of money the broker holds in trust for other, and the broker doesn't necessarily have to hold the escrow, and we'll talk about that in a minute. He can have a title company or an attorney hold it. The deposit is the money delivered to a licensee in connection with a real estate transaction, right? Does a broker have to, I'm sorry, does a buyer have to give a deposit on a contract?
Yes.
No.
No, they do not have to. Okay. It just shows good faith. We'll talk about good consideration versus valuable in chapter 11. Now, the deposit could be money or anything that can be converted into money. There's a question on the state exam. I don't know if it's sitting online or not, but it was very prevalent when in the live state exam, and that is a buyer gives stocks as deposits. What must the broker do with the stocks? Turn them into cash and deposit it into his escrow account. Okay. Now, I want you to know also the time frames for the deposit of this money. 4 days, 3 nights. The sales associate can hold the money for 1 night. And if you look at this slide here, you'll see a word that pops up 5 times. And that's because, and this will be on the state, the money must stay in Florida, guys. It cannot be deposited in any of the 49 states. That also goes for landlords, and that's on the state exam. Okay? Money stays in Florida. Okay? Now, the sales associate must give the escrow money to the broker immediately. Immediately defined means the next business day. right? So the broker has 3 days coinciding with the day the sales associate received it to deposit it into his escrow account. So for example, a sales associate on Wednesday shows property, and that property, he brought the buyer to the office and filled out the offer here at the office. And since he was here at the office, he just left the check and gave it to the broker on Wednesday. Based on what I just talked about, when does the broker have to deposit that money into escrow?
Monday.
Monday is correct. Yeah. The sales associate gave it to the broker the same day. He could have held it for a night, and then the broker deposits it by Monday. We don't count weekends or holidays. Now, let's say another one of his agents that same Wednesday put together a deal, went and showed a property at 7 p.m. and had the buyers come to his house. He's got a home office there that he uses, and he puts the offer together there. And as mandated, he brings it over to the broker on Thursday, the next business day, as defined. When does the broker now have to deposit that money into escrow?
On Tuesday.
Wednesday.
It changes nothing. Good, Christopher. Monday. The associate has the right to keep it for one night, but it doesn't change the 3 nights that the broker has. They coincide together. So it's a 4-day, 3-night cruise. The sales associate could join the broker for one night. Just look at it that way. Or the sales associate doesn't have to go at all, and he gives it to him the same day. All right, it changes nothing. The broker has 3 nights, which would be 4 total days. The sales associate by law can keep it one night, one business day, immediately.
Wait, I'm sorry. Can you explain that last part one more time?
Sure.
When did the associate get it, on Thursday night?
No, he gets it Wednesday night.
Oh, okay. Okay, I understand now. I'm sorry.
Now you understand, right? The first guy did the offer at the office. He was here. He's like, hey, might as well leave the check for the broker. I'm here. The other guy did it Wednesday night. Now he's got to take it to the broker Thursday, but it doesn't give the broker an extra day.
Okay, okay.
Is everybody clear with that? That's important.
Yep.
All right, good. Escrow checks payable to the sales associate. This is not in the Gold Coast book in case you went there. But this reminds me that there's something in the Gold Coast book that is not in this book that used to be. So the sales associate gets a check on a Friday. Is the money due to the broker Saturday or Monday? Monday. We never count holidays or weekends, James, but a good question. So he writes an offer over the weekend. He takes it the very next business day. Only business days.
I have can you clarify something for me?
Yes.
Do you also count for the time the associate received the check as the 3 nights? Like if they do have one night, does the broker have 2 nights?
Yep. Now it counts into the 3. Yes, it does.
Thank you.
It does. All right.
Well, I'm sorry.
Go ahead.
For me, it didn't click till now because I remember being lost when we talked about this before. But for me, that made it click is that it's the broker. Like, it's the licensee, it works for the broker. So
That's why
the broker has 4 days, 3 nights, period. Like, it doesn't matter what the associate does.
Exactly. Like everything. That's why I start with the broker. It's all about the broker, right? The sales associate just happens to have one night. Yeah, I know that question's on the exam. All right, so this question also pops up in the exam. It's not in the Gold Coast book. It's not in a lot of the other material. It's in here, but there was something removed from here that's still on the state exam, and 2 mortgage terms as well that have been removed from here but are still on the exam. And I'm going to talk about those now. Escrow check payable to sales associates. Somehow, as last resort, you can't get them to change the check. You sent them over to the bank to get a cashier's check. You told them to make it out to ABC Realty. They weren't paying attention and they made it out to Jim Lopez, right? The associate. You can accept the check and turn it over to the broker immediately, next business day, and endorse it, and the broker deposits it into escrow. Okay? As last resort, you could do this, right? You take it, you endorse it, and give it to your broker the next business day. Now, what's no longer in this book and on the state, and it's in the Gold Coast book, is we cannot, licensees cannot be involved in the raffling or offering real estate based on chance, luck, etc. We can't raffle off a house, make a commission. But my understanding is on the state exam that an owner-developer does it. An owner-developer owns the home. He's an unlicensed, it's an unlicensed entity that sells, leases, or exchanges his own property. Therefore, he's good to go. He can raffle off a property, but keep in mind, a broker could not be involved in offering property in that manner. Okay. Now, there's 2 clauses in the mortgage that are no longer in the books, but they seem to pop up on the state. The first one is the escalator clause. The escalator clause allows the mortgagee, the lender, right, to increase the interest rate if the property ever becomes non-owner occupied. So, Jim and Jill bought a house, owner occupied. 7 years later, they decide that they're going to be sailing the world in their sailboat, and they're going to live on their sailboat. The mortgagee catches wind of it. They exercise the escalator clause, and that allows them to raise the interest rate on the property. Because when you buy a property that's non-owner occupied, you're always going to get a higher interest rate than when you're buying owner occupied. It's not a commonly used clause within a mortgage, but it's on the state. The next one is the exculpatory clause. I'll spell it for you. E-X-C-U-L-P-A-T-O-R-Y. Exculpatory. For those that speak Spanish, culpa. Yeah, you don't have any culpa on this. And what it is the promissory note makes you personally liable for the debt, and the mortgage is what the bank uses to turn to the collateral upon default. If there's an exculpatory clause, the lender cannot go after you personally. Any questions on those terms? They pop to mind when I see this here because they're on the test. They were in this book. They're no longer in the book. In case you used Dearborn. If you went to Gold Coast, is escalator and exculpatory still in the Gold Coast book?
Yes.
It is, and it's on the state, right?
Yeah. I have a question. Can you use an actual example on the last one there when the lender cannot come after you personally? Is that after maybe a foreclosure?
Yeah, it would be upon default, foreclosure.
Okay. Thanks.
So upon default, right, the lender has 2 choices, and they could exercise both. A, usually they use the mortgage, go after the collateral. So you owe them $350,000 after they accelerated, right? And then, well, they auction it off and they only get $320,000. What happens to the other $30,000? They can turn to the promissory note, make you pay them personally. It's via deficiency judgment. But now, if there's an exculpatory clause written in, they can't go after you for the $30,000. Okay? So, yeah, somehow they took them out of this book. I'm not a big fan of the Gold Coast book. I prefer this book, but somehow these terms were in here and they've been removed for whatever reason.
Now, what's the cases to get a clause like that written in?
Yeah, it's slim to none. Exactly. Slim to none. But you know what? A lot of this crap in here is slim to none happening. And you still need to know to get a license. Right? Interest-bearing escrow accounts. First off, this is another fantasy land because pretty soon we're going to start having to pay to keep our money with banks because there's no such thing as interest-bearing bank accounts, period. Really. And if it is, it's not even worth talking about. But nonetheless, back in the 80s, shit, if you had a bank account back then and you had some money in it, you were earning interest. You can have an interest-bearing escrow account as long as everybody to the transaction is involved. The seller, the seller's broker, the buyer, and the buyer's broker, and who's earning the interest. On the state, it was that the broker, as long as everybody's aware, can keep the interest. Right now, there's a question on the exam that says kind of like the buyer mandates or almost says like, hey, I want my escrow money to earn interest. Can that happen? Yes, as long as all parties are aware. That's what's on the exam right now. Buyer wants to earn interest. Cool, perfectly fine, as long as all parties are aware. Now let's talk about misappropriation of escrow funds. Commingling is the illegal practice of mixing your money with others' money, right? We do have a threshold where we can put our own as brokers' money in there, and I'm going to talk about that in a minute. But the escrow account has to be a separate account. They do give us a threshold of how much money we can put in there. Conversion now is a big no-no. Conversion is where, well, I'm going to take from my escrow account because I'm going to hit the jackpot at Seminole, and if I don't, I got 3 closings next month. I'll put the money back. You are using other people's property, in this case, their money, and that's conversion. Sadly, conversion, you see when, I watch their meetings, you can watch the meetings through gotomeeting.com. It's kind of like Zoom. And it starts with the intention of conversion. And what happens is you start stealing from Peter to pay Paul. And eventually, you don't pay Peter back. And most of it is, sadly enough, is people with addiction problems like gambling and drug addiction, etc. Now, here is the threshold for commingling. If you have an escrow account that you use for sales, you could put $1,000 of your own money in it. If you have an escrow account that you use for property management, you could put up to $5,000. The question would be is, if you have an escrow account for both, how much money can you put in there? And the correct answer would be the higher of the two, 5,000. So there's a question about what is incorrect about a broker's escrow account, and that's that he could put 6,000 of his own money. He can only put 5,000. That's on the state exam, guys. Look out for the fact that he cannot put 6,000. All right, this is on the state exam. When a title company or an attorney is holding escrow, and they must be in Florida, what do you have to disclose to the seller on the contract? Their name, address,
Address and phone number.
What was that?
Name, address, and phone number.
Yeah, name, address, phone number. That's it. Not their license number, not their errors and omissions. They get kind of fancy. Also, guys, with you putting your name in advertising, you don't have to say you're a sales associate, right? What I went through, your last name, your phone number, and make sure your phone number is properly disclosed. You don't have to say you're a sales associate. Now, there's another question, right? And it comes from here. And as a matter of fact, A, B, C is in this order. What is incorrect about a title company or an attorney holding escrow? Well, A is correct. You must disclose name, address, and telephone number. You must ask for written verification within 10 business days. And within those 10 business days, you must provide the seller or the seller's broker with that verification. D says 15 days. Well, that's the odd guy out. So 15 days is incorrect. That should be a very easy one. I'm telling you, this online test is really dumbed down. I'm giving you a lot of what's on it. Who's seen that question? Nobody?
I did. I saw it. And
You saw it, right? And it's a very easy, well, you saw maybe this question earlier, then you see 10 and 10, and then all of a sudden 15. Well, 15 is incorrect, right?
yeah, they really mess with you on that one.
Yeah, and here's the thing is it's very psychological. You know, they have actually instructors write this, and then they get psychologists to comb it, to
Yeah.
trick you.
I felt that.
Yeah, so, you know, they're asking what's incorrect, and then you're just like, well, one of the two 10s has to be incorrect because why is it repeating itself? No, what's incorrect is the 15 days. All right, conflicting demands. So not all deals end up in closing, right? Buyer and seller, buyer wants the money back, seller wants the money. What's the first thing the broker has to do? Notify FREC in 15 days. Then he must implement one of the settlement procedures within 30 days. But what I want you to know is that these dates run concurrent. Okay? So for example, if the broker notifies FREC in 14 days, how many days does he have left to implement a settlement procedure?
16.
16. Thank you. Now, here are your settlement procedures. Mediation, non-binding, third party, sucks. I hate doing these because the seller and the buyer show up. Well, now they're on Zoom, so it's not as bad. But when they were live, damn, they had to see each other and they hate each other at this point, right? Arbitration is the way to go. It's in the listing. Get the seller to initial the arbitration aspect. Arbitration is the cheapest. It's a third party. Sometimes it's a panel. They split the cost. They find the neutral arbitrator, and they settle it that way. Here in South Florida, particular Miami, since we have attorneys everywhere, everybody loves to sue everybody. Right now, it turns into ego. I'm going to sue you and watch, I'm going to win, right? And it's a $5,000 deposit, but by the time they pay a retainer and the hours start ticking, you're spending more than $5 grand on an attorney and court costs to fight for $5 grand. It's stupid. It's ego. But what I want you to know about litigation is, and don't worry about when the broker can make a claim, but there is certain cases where the broker can claim part of the deposit. If the broker does not intend on making the claim and the broker is holding the money, and the broker does not want to make a claim and it ends up in litigation, he would deposit the money with the interpleader, meaning he deposits the courts, washes his hands in case he gets, the only time that, you know, maybe he would be involved if he is subpoenaed. And lastly, you have an EDO, an escrow disbursement order. This is where you send it to FREC and let FREC make a determination. I have found over the last almost 20 years that FREC likes to give the money back to the buyer, no matter how egregious the breach was.
But this is only in cases where it's deposited in the broker's escrow account, right? If it's in
Correct. If it's deposited with a title attorney, this is mediation, arbitration, and litigation would apply, but EDOs they would not be. FREC would not involve themselves with an EDO if the money is being held by a title company or attorney. If it's an attorney, the bar will actually, but FREC will not. Some cases where you don't have to go through conflicting demands. HUD tells you, you win the bid, you don't close, you lose your deposit. So the broker or the title company just gives the money to the HUD. The other two is where the buyer gets their money back. If you're buying a condo, resale, you have 3 days to read the bylaws. You don't like the fact that you can't go swimming in the pool at 11 o'clock at night, you back out, you get your money. That's on a resale, 3 days. On new construction, you got 15 days to read and back out. If you don't like what's in there, seller can't say, I want your money. You had the right. And the biggest reason the buyer gets their money back is they made a good faith attempt to qualify for financing, and they did not. Rental information and list. They love to ask about this crap. Remember, we talked about if you put together a bullshit list, you are going to be charged with a first-degree misdemeanor. Now, if you put together a list and you messed up and that you were supposed to include cats, you know, that were permitted and somehow you didn't, and they come back to you within 30 days, you got to give them 100% of their money back. Okay. Now, the second, the 75% is what they love to ask. There's 2 questions on the state exam. And if you sell a list and the person does not obtain a rental from the list and they come back to you within 30 days, you have to give them 75% of their money. The first one is you sell a list to some lady and she decides, I don't want to rent anymore. I want to go live with my parents and I'm going to save up money to buy a house. She comes back and she demands her money. You have to give her 75% of it. It isn't, I get how it's not your fault that she changed her mind, but see how they pry at you like, what the hell is it my business? This lady, you know, came over here, made me print this list out, and now she's changed her mind? You know, no. Yes, you do have to. Then there's a situation where a broker sells a list for $100 and the prospect doesn't obtain a rental, comes back and the broker gives them $50. What's true? What's true there is that he violated chapter 475 because he was supposed to give him $75. Who establishes commissions? We talked about this, the broker, right? State of Florida, the Board of Realtors doesn't, etc. Now, antitrust laws can only happen in such a small town. I lived there for a little while, actually, right out of high school, Key West, Florida. Bunch of 4 brokers from Key West get together and they decide to set their commissions at 7.5%. What is true about this? It is a violation of the antitrust laws. That's the way it's popping up on the online course. Before, on the live course, it was they're on the golf course, one guy lowers his commissions, and they have an argument, and they play this whole scenario out. Now they're really dumbing it down. It's pretty much 4 Key West brokers get together. They decide to charge 7.5%. What is true? It is a violation of antitrust laws. It stems from the Sherman and Clayton Antitrust Acts. On the state, guys, you've seen it. Kickback, rebates, and unearned fees, RESPA, right? We can never give money to somebody who refers us business other than, you know, that thank you note. We can never move money around any service-related industry, meaning anybody that's helping us go from the contract to closing. The surveyor, the mortgage company, title company, appraiser, home inspector. Illegal to kick back money back and forth. Now, we can receive money from, let's say, a handyman, a gardener, and this is on the state exam. We can receive the kickback as long as all parties are involved. One of the options within that questions there tells you that the sales associate with the broker's permission receives a kickback, and it's perfect right up until that point. But why is that not the correct answer? Is because it says irrespective of the parties involved. So your broker doesn't necessarily have to get the money and then give you the money. A broker can tell a title company to to pay you directly. But what makes that particular option wrong is the irrespective to the parties involved, meaning the parties involved were not informed. So the correct answer there is the broker, you know, at time of placement of the kickback, all parties are informed. And guys, this is where I end chapter 5. I have no rhyme or riddle for you guys to remember this. But I will tell you that they like to ask you which of the following is not one that can't register as a real estate broker, and corporation sole. Corporation, as you see on bullet number 5 and the first part of bullet number 1. A corporation sole is a setup for a church. Okay? I want you to know one more thing before we wrap up chapter 5. And that is, all general partners who deal with the public must be licensed real estate brokers. What does that tell me? That I can have general partners who don't deal with the public, and they can be partners, general partners. But that also tells me that sales associates can't be general partners. They can be limited partners or shareholders. So again, all general partners who deal with the public must be licensed brokers. So you can have a licensed broker who deals with the public, you can have various, and you can also have a general partner who doesn't deal with the public. But sales associates can't be general partners. They can be limited partners or shareholders. Any question, guys? That's chapter 5, 12% of the exam. Kind of took us to 2. Takes me about 15 minutes to do chapter 7, but it's 2 o'clock, and honestly, all running around this morning. I really didn't eat breakfast or anything. So let's just take lunch now. I'll do that quick 7 afterwards, and we'll do 8, 9, and then we'll do math.
One thing before you leave, you said sales associate can be limited partners in what?
They could be limited partners in a brokerage, but they can't be general partners. Or they can be shareholders. Limited partners are shareholders, but they cannot be general partners.
Oh, okay.
I have a question. I have a question. How long is it before you said you could sign up to take the state exam online or at your home? I mean, I didn't hear that part where you said how long it takes for you to.
You could pretty much get an appointment like for the next day.
Oh, okay, gotcha.
So yeah, just make sure you have a strong internet connection. You have to have a webcam. They proctor it. Chris, same day. Yeah, I've heard that, but I don't want to promise anybody the same day. But it's quick. Yeah.
Okay.
I can guarantee you that you can get in the next day. You have to have a webcam. They're going to record you. You can't have anything on your desk. You can't read the questions out loud, but well, you can't read the questions out loud at the center either. And if you got kids or other people in the house, make sure they're quiet.
Yeah, and another question, I don't know if this has nothing to do with anything, but what if I moved from the time I filled out my application and did all my fingerprint and everything, and they, sent me, so I could take the exam? Do I need to change my address now, or how do I do that?
I'm going to hit pause on the recording. Ronnie, you stay around.
Okay, thanks.
Anybody have any other questions before I hit? Go ahead.
I just wanted to, so on the business entities that may register as a real estate broker, the answer is sole corporation?
Corporation sole may not register as a real estate brokerage because it's a church.
Okay, that's the only one that may not.
Well, no, there's a bunch of others, but that's as far as I know, state exam.
Okay, thanks.
And lunch is for 45 minutes?
Lunch, 45 minutes, yeah, so we can get through this. Hopefully most of you are eating at home. I'm at the office. There's like a Wawa up the road. I'm going to run over there and just grab one of the prepared sandwiches.
Okay.
Yeah, they don't even allow you that paper. There's some negative to it, but.
Yeah, I was going to ask for online testing, like I have to find a place to take the test, I guess, because you can't like have anything on your walls or anything, or I don't know how it works.
Yeah, I mean, I wouldn't have a dry erase board up there with a bunch of writing, but if you have a painting or something like that, that's not going to matter. But you can't have anything on your desk, not even paper. They have like a little easel type thing that pops up. If you have a touchscreen computer, that's going to work better for you. If not, you got to type in like formulas, right? But here's the thing is that it's so dumbed down that I find that it's worth taking it online. Again, I asked this question early on. Those of you that took it live already know it's much easier this way. They're like 2-sentence questions instead of, yeah, you can't have paper for the math problems. Guess what? The math problems are a lot easier.
About a calculator. Can you have a calculator?
There's a calculator on the screen. There's a calculator on the screen, just like any computer would have, right? But you can't have a tangible one on your desk, no. Any other questions before I hit pause? You can't have anything. Yeah, pretty much nothing. Can't get up to use the bathroom. So use the bathroom beforehand.
Can't cover your mouth.
Can't cover your mouth. I've heard all of these.
You can't even look to either side.
Yeah.
Up, nothing.
Yeah, but remember on the life test, you can go use the bathroom and things like that.
Right.
But guys, like I've heard students finish it in an hour and a half and pass it. Can you use an iPad or a PC only? I think you would have to do it on a laptop or a PC. Maybe somebody who's done it can answer that for you. Make sure you have a webcam that works. They do proctor. And believe it or not, there's like somebody actually literally they're watching. It's not like if you make a funny thing, somebody pops up. No, there's somebody there watching you the whole time.
Can't do anything.
Yeah. I started reading out aloud and he came on.
Yeah.
Yeah, but here's the thing: is if you read out loud at the testing center, they do the same thing. So that's no different. The testing center live, you read out loud, they're gonna call your attention.
And if you do have like a computer that can't be moved, they have you take a meal.
Well, yeah, they make you circle the room so they can see the whole room.
And then you can't move. And then it tells you right there, you cannot move.
From that position, yeah.
Yes. Mm-hmm.
But hey, the positive is it's a lot easier. If you can deal with those things, I'll tell you the test is much easier. Then again, I haven't taken it. It's just, students I tutor, students that I know have gone. Test questions.
Ideally, you'd want a touchscreen computer with a stylus so you could
if you have if you have like mine, like a touchscreen where I work the math out and all of that, that little easel thing, instead of typing into it, my understanding is you can use like a stylus in there to put your formula. All right, guys, I'm going to go ahead and pause the recording for lunch. It is right around that 2 o'clock, right? So we'll go till 2:45. I'll get started at like 2:50 sharp, okay? Just to make sure I give you the full 45 minutes. Like literally at 2:50 sharp. You can exit and come back in, right? I'll let you back in from the waiting room. All right, I'm going to go ahead and hit pause. Ronnie? Give me a second.
I'm here.
They can discriminate up to now. Lastly, that person that owns 3 or less, if during the last 2-year period sells only 1 home or less that they did not occupy, they can discriminate. So once again, if you own 3 or less homes, you have only sold 1 home in the last 2 years that you didn't occupy. So you're not in the business of flipping properties, right? Because you only sold 1 in the last 2 years that you didn't. You don't hire a broker. It's not based on race, and you don't have discriminatory advertising. Sadly enough, you can discriminate. Okay? So know that. So you can say, I don't want, for example, children in my condo that I'm going to be renting out. Can't put that in the ad, and I've seen that in ads, which is crazy. But you can see how I can use this with all the others, right? Now, housing for older persons. Once you leave like Miami-Dade County, you guys are throughout Florida. I'm sure you got a bunch of these in your neighborhood, right? Where Jerry's dad lived, what was it, Via Vistas or whatever, one of those 55 and older communities. I want you to concentrate on the second bullet. As long as 80% of the units are occupied by persons 55 or years of age or older, they can reserve the rest of the housing for that, for those persons, okay? This allows them to be exempt from familial. Now, the one I know is on the state exam is the church. A church or a private club, but in this case, I know the church is on the state, does not discriminate on entry into their church, right? So they don't say no people from national origin, will say no Cubans or Puerto Ricans, and I'm Cuban Puerto Rican, so I'm just going to use, you know, my nationality. Can't join the church. Well, they can restrict the housing that they own on the church for just members of their church. It's called convalescent homes, right? Some churches have these for members that are going through tough economic times, things like that. As long as they don't violate 1968 with entry into the church, they can reserve the housing that they own for just members of the church. Steering and blockbusting you want to be familiar with, but steering is the one that's really on the state. And I want to ask you guys a question. I want you guys to chime in. A Hispanic American couple walks into your office and tells you that they want to purchase in a predominantly Hispanic American community. Is there a violation?
Yes, that's steering.
That's steering, right? Even though they're doing the steering, it's steering. Okay? So, don't fall for, you know, these laws only pertaining to us, you know, as associates or brokers. Furthermore, if you're going to go forward with doing it, it would be considered steering, okay? They either use the Hispanic American or they use African American couple, okay?
I have a
Now,
question.
go ahead.
It's actually on the other slide just before this one, on the church thing. So if like the religious organizations say, I don't know, it's a Catholic a church, and so they only let Catholics in, and they have their they own the residential property, and then they only let members of that church in. Is that allowed or not allowed? That's what I'm confused on.
Yeah, it's allowed. As long as they don't discriminate into entry into the church, right? They're allowed to reserve housing for just members of their church. Now, if this is a, I don't know, if this is a Catholic church and you happen to, you know, be of another religion, well, why would you really want to join that church, right? Just like I live next to a German American club. I'm not German American. On my ancestry, there's not even a drop of it. You know, Western.
But I get that part, you know, like why would you want to? I agree, but some people do want to for whatever their reasons are. So that's why I'm confused on that. I mean,
what I find with some students, and I don't really, you know, want you to take this the wrong way. I think you're overthinking it, right? I think you're overthinking it, but I understand where you're coming from. But they won't give you a scenario like that, right? Where it's just like, you know, somebody decides to leave their, you know, Protestant church to join a Catholic church, and you know, they decide to deny them because they know they're Protestants. They won't do that. It's just as long as they don't discriminate onto entry of it. I'm sure they're not going to throw religion as part of it, right?
On the North Carolina real estate test, that's the only reason I'm asking about this one. And it was 10 years ago, but that's why I was curious, and it was a very similar question. So I was curious. I don't know what the answer actually was. I still don't, but that's why I asked.
I would go out and assume that they would, you're converting religions, that they would have to let you in. Because religion is a protected class. So, you know, if you are going to be converting from, you know, you're doing the Jewish religion and you want to become, you know, Christian or vice versa or whatever it may be, I think they have to let you in. They can't discriminate and say, well, no, you can't convert, for example. Okay. But damn, North Carolina gets tricky like that, huh?
Oh, yeah. Oh, yeah. It was a country club / church. It was a church that owned housing, kind of like a country club almost. And they did not want to let certain people in that weren't exactly like them. And the way that they got around it was through, the church affiliation, and you could not join if you were not of that.
But here's the thing. This is what we're doing now is national. So if there's anybody here seeking mutual recognition, this is national. This is going to be every state down the line. And my understanding of the Fair Housing Act, and I've studied it, I'm in law school, is only for housing, not for a country club, not.
Well, it was church and housing. They kind of, but anyhow, that doesn't matter. I was just curious for the purpose of the test, and you answered that question.
Yeah. I don't think it would. I don't think they would be allowed to exclude people from a country club.
Okay.
But then again, country clubs exclude people all the time. So, we're going too far.
Just more curious for this test. I'm taking the test tomorrow, so I was more curious for purposes of.
You'll see the Convalescence Church, and I believe it's their discrimination is based on something that's not going to be religion, right?
Okay.
Blockbusting. Using entry or rumor of entry of a protected class into a neighborhood to urge sellers to sell. So for example, do you see all of these families moving in with small children? There goes the peace and quiet, guys. It's time to sell your home. And then anybody here can see how, I can use any of the others. Well, Hialeah, if you're from Miami, right? Hialeah, back until about the early 1960s, was predominantly a white neighborhood. Now it's pretty much, probably got more Cubans than Little Havana does. In that era, a lot of Cubans were moving to Hialeah. So a lot of real estate agents went in there and they blockbusted. They were like, hey, with all these Cubans moving in, the property values are going to go down. It's time to sell your property. And sure as hell that did happen, and that would be one example of blockbusting that took place, over 50 years ago. All right, I think this is where I'm seeing scores in this chapter, like 2 out of 4, something like that. And I don't think other schools harp on this, and I've seen where online courses don't even talk about the Florida Fair Housing Act. If there is an example of discrimination and you clearly can see it, and then once again, they put these in order for a reason. A says, violation of the Fair Housing Act of 1968. Bingo, yeah, that's an easy one, but you didn't keep reading. And somewhere down the line, CD says, violation of the Fair Housing Act of 1968 and the Florida Fair Housing Act. Why? Because the Florida Fair Housing Act actually follows the federal law to a T. So you're technically violating both within the state. Okay? So the same 7 protected classes, and it actually adds a few other different things, but it's different terminology, really. But I want you to know strictly that it is just like the 1968. So if there is discrimination, it's both. All right, 88, the Americans with Disability Act. The key word here is right down here with the slash as a bullet. Modifications may be required if readily achievable. So if you're a landlord and you're renting your house and somebody who's handicapped comes and wants to rent it, and it's a 2-story home and they're in a wheelchair, would putting an elevator in the home be readily achievable? Absolutely not. Would putting a wooden ramp at the front door and grab bars in the bathroom be? Yes. So the key word is as long as it's readily achievable, the modifications must be done. Whose responsibility is when the lease ends to bring back all the modifications? The landlords. That's on the test too, right? The landlord's responsible for making the modifications and returning them if he or she pleases to do so. Another thing of ADA that's not in really the book, but is on the state exam, and it's really part of the brokers, is for commercial, right? And we're talking about handicap spots. For every 25 handicap spots, for every 25 normal spots, you must have one handicap spot. So for example, I owned a small commercial building down in Key Largo. It literally had like 5 parking spots. One had to be handicapped. What if I owned a, medium-sized shopping center and I got 26 parking spots? How many handicapped parking spots do I need? 2.
2.
25 or any fraction thereof. Jen, maybe or must be? Must be. Things I'm talking about must be as long as they're readily achievable. It does say may, but it's a must. I know, slide says may. Slide says may, but the reason may is because readily achievable is up to interpretation, is why I believe. Now, I'll tell you the 25 per parking spot is a must. Okay, but the whole readily achievable can be interpreted in a courtroom differently, right?
I have a question. I'm sorry to go back. If there's the clear example of discrimination, you're violating both the Fair Housing Act and which is the second one you're violating?
The Florida Fair Housing Act, because they're both exactly the same.
Okay.
Florida follows the federal to a T, so look out for that on the state. Don't, usually they put A, B, C, D in an order so that you don't go through it. You guys need to read all 4 of your options. All right, so Residential Landlord Tenant Act. I want to touch on a few things here, and let's move forward. Deposits and advance rents. This pops up on the state exam, right? And the landlord must account for deposits and advance rents in any of the following ways, right? A, put it in a non-separate interest-bearing account. B, put it in an interest-bearing account and pay either 75% of the interest earned or at least 5% simple interest. And then lastly, you could post a surety bond for the amount of the advance rents or security deposits, or 50 grand, whichever is less. James, you're spot on. Now, which is one of the ways, this is on the state, guys, which is one of the ways that the landlord, which is the incorrect way that a landlord would account for the deposits and advance rents? And that would be to deposit in any bank in any of the 49 states. Why? Money must stay in Florida. Remember that. Money must stay in Florida. Now, you need to notify the tenant within 30 days of which one of these options you chose. So I just want to pull up a question on the red slides real quick. And then there's one more thing I want to talk about for Landlord Tenant Act, and we'll move into chapter 8. Number 36, go ahead and type in what letter you believe it is. Damn, I got a good crowd here. You guys are really listening to me. Perfect. All the other three are options. The only one that must be is to notify within 30. Here we go. All right, vacating premises. You had an estate for years, which we're going to talk about here in chapter 8. Estate for years is a fancy word for a lease, right? The lease is now terminated. The landlord has the security deposit. And if the landlord does not intend on making a claim on the security deposit, he must return the money within 15 days. Now, if the landlord intends on making a claim, he must make that claim within 30 days. So in writing, hey, out of your $2,000 deposit, I'm keeping $400 to shampoo the carpets and paint, a door jamb, whatever it may be. My understanding, what's on the state exam right now, is that the tenant has 15 days to refute the landlord's claim. Okay, so the 15 days to return, 30 to claim, 15 to refute the claim. That's on the state exam, guys. And that's what I go over in chapter 7. Any questions? All right, let's go into chapter 8, which joint tenancy, tenancy in common, all of that is something you guys have a little bit of trouble with. So I'm going to use the whiteboard for this. I'm going to start with freehold estates, and then I'll fill in the rest of the chapter, right? So freehold estates, there are two types of freehold estates. You have life estates and you have fee simple estates. Now I'm going to start with fee simple. Fee simple has several categories. The first one is going to be in servality. Comes from the term severed ownership, guys. One person owns this property. Not a whole lot to it. They have all the control. Upon their death, they can sell it. They have nobody to count on. They can leave it to who they want. It'll pass to their heirs, etc. If they don't have heirs, we'll talk about that in chapter 9. Now, concurrent fee simple estates, we have 3. I want you to concentrate on 2. First, we have tenancy in common. Right? Concurrent means 2 or more people. Here, they could have equal or unequal shares. This is the only one that allows for unequal, and why I'm putting it in caps, shares. And title can be taken at the same or different time. The only one that where you could take title at a different time. This goes to the heirs, meaning there is no right of survivorship. Okay? Tenancy in common. This is most commonly used by business partners, right? How would a family want, their father or to purchase a home with a business partners to develop condos? Tenants in common, right? In the case here, if he passes, it goes to his heirs. So that's why they want him to purchase it that way, right? They're protected. Whatever investments made there will descend to the heirs upon death. Now, I want you to concentrate with tenants in common on the unequal or different. So, for example, I have a $1 million apartment complex, right? And a buddy of mine, he's always been, hey man, it's a badass building. You always have it rented, blah, blah. And I get a good, stock tip across my desk and I need some money. So I reach out to Caesar and I tell, hey, listen, man, you want to buy into the apartment complex? I'll give you 20% shares in exchange for 200 grand. Yeah, sure. Well, he's taking title at a different time and he has an unequal share. I don't have to tell you anything else. We're tenants in common, right? I'm 80%, mine descend to my heirs. He's got 20%, his descent to his heirs. He could sell it at any time, etc. Okay? Now, the next type of concurrent estate would be joint tenancy, and I'll use pink here. It is equal shares only, and you must take title at the same time. And this has right of survivorship. I mean, who would buy this way, right? You die and the surviving co-owners or co-owner would become the owner of the property. I will tell you that same-sex couples, prior to the Marriage Equality Act of 2008, purchased property in this way, right? I've seen this where husband, wife, and they needed the dad to qualify. They did it as joint tenants. Why? Because, well, if the normal circle of life takes place, he's going to be passing away before they will. And then he passes away, he automatically falls off the deed. There's no having to go through probate or none of that to get his share. And then they have a joint tenancy. And I'll get into what they would similarly have had regardless. But let's talk about the weirdness that the state exam uses, right? They use like 4 people get into this. And I don't wrap my head around why 4 people would become joint tenants that are complete strangers, right? I mean, I could picture, what is it, Selma and Patty, Marge's sisters from The Simpsons buying this way, right? Because, they live together, they buy the house together, with one dies, the other one gets it. I could see somebody who's been divorced a few times, moves in with a significant other. I wouldn't want to involve government in my bedroom either. So I've, been divorced. I would not remarry, and have to go through the legal mumbo jumbo. If I decide to buy a property with a woman at some point, I would probably do joint tenants. But the state, of course, is 4 people: Jim, Jack, Mary, and Lucy. They own a property together as joint tenants. They each have 25% ownership. right? Because it has to be equal, and they took it at the same time. Now, Jack dies. What happens to Jack's shares? Well, it gets evenly distributed between Jim, Lucy, and Mary. Okay? So now Jim, Lucy, and Mary are 33.3% owner. What happens next? We'll say Mary dies. What happens to Mary's 33%? Well, it's going to get distributed between Jim and Lucy. We'll say Jim dies. Jim's shares go to Lucy. What does Lucy now own?
100%.
100%.
And what is that called by herself?
Fee simple.
Fee simple.
Fee simple. But which fee simple? Because all of these are fee simple.
Severalty.
Inservality. She owns it all on her own, one person. Good. I got some good stuff here in the chat. Now, of course, the state exam takes twist and turn and gives you a weird situation, which would even joint tenancy is weird enough. They add this crap into it, which nobody would ever agree to. So we're going to use Jim, Jack, Lucy, and Mary again. They own a property. And they give permission to Mary to sell her shares to Maria. Somehow, some way, I don't know why they would do that, but they give permission to Mary to sell her shares to Maria. So now Maria is not a joint tenant, though, with the other joint tenants. So she has no right when the others die to get their share. But she bought at a separate time. So what is she with the joint tenants? Anybody want to help me here?
Life estate?
No, she doesn't get a life estate. We're talking fee simple. Life estates is coming next, guys.
Tenancy in common.
Those on the chat, I don't know why you guys are unmuting yourself, because you're spot on, right? So Maria is a tenant in common with the joint tenants. So Jim, Jack, Lucy, and Maria have 25% ownership each. Jim dies. What happens to Jim's 25%? Well, it goes to Jack and Lucy. So Jack and Lucy are now 37.5, 37.5, and Maria has her 25%. We'll say next that Lucy dies. What happens to Lucy's 37.5%? It goes to Jack. Jack is now 75% owner, and Maria is 25% owner. What do they both own? What do they have?
Tenancy in common.
Unequal shares. He was the last surviving joint tenant. I got a really good, smart crowd. I'll tell you, the last one I did, it was, people were kind of confused about all of this. Some of you must have taken this class at, somewhere reasonable. They didn't really use the Azure Tide. Yeah, right? So unequal shares, sole surviving joint tenant. He is now a tenant in common with Maria. Maria has 25%. He has 75%. He can now sell his shares. He can now leave his shares to his heirs. There's a third concurrent ownership, and I'm not even going to write it on here because I need space for my life estates. And that is a tenancy by the entireties. A tenancy by the entireties, guys, is a joint tenancy. All of the same features that joint tenancy has. The difference is it can only be two people, because as far as I know, polygamy is illegal, and those people would be married. Married couple bought it at the same time, 50-50, one dies, the other gets it. Make sense? All the same exact things of joint tenants. Equal share, 50-50. They bought it at the same time while married, and right of survivorship. Usually we die, right? The men, she gets the property. 100%. Any questions on these concurrent or anything of fee simple estates? A lot of you have trouble with it. I don't find it to be too difficult. Hopefully I explained it in a way that it was easier to understand than when you first got it.
You just took what took 5 days to understand in the book and made it so easy. Thank you.
You're welcome.
I have a question. You explained severalty.
Inter
Oh yeah, how do you say it? Is that the same as fee simple absolute?
No, fee simple absolute is all of these are fee simple absolute.
Oh, okay.
All of these contain the full legal bundle of rights. So I was going to bring that in now. Deep C, the right to dispose, enjoy, exclude, possess, and control. Now, a lot of people get stuck. Well, what do you mean? Jim didn't have the right to dispose. Well, somebody did at some point in that concurrent ownership have the right to dispose. Okay? Inservality comes from the term severed ownership, meaning apart. Because I get a lot of students that say, oh my God, it has the word several in there. How can it be one? Well, really, it goes back to severed, apart, one person. Okay? But these are all fee simple, absolute, right? They all have the full legal bundle, all four of them. I'm just going to, I guess I'll write up here, tenancy by entireties. Is a joint tenancy, but must be married, right? After the Marriage Equality Act, it can be husband, wife, wife, whatever it is. But two people.
Do they both have to be on the deed?
Yeah. We're going to talk about when there's only one in the deed and it's owned inservality in a minute. But then they get married after the fact. We're going to talk about that. Because it really falls on their life estates. Any questions on this, guys? Did this kind of clear up any doubts you guys kind of have with this? All right, so I'm going to move into life estates. There are two different types of life estates, okay? And the first one is an estate in reversion. This is where the grantor gives a life estate. For example, I bought my mom a house. Upon her death, I want it to revert back to me. Mom has a life estate in reversion. It reverts the day she dies back to me. Why would I buy it this way? Well, I got two siblings, right? And, well, I bought mom's house. The day mom dies, I don't want to have an awkward conversation with them about, what about mom's house? What about mom's house? I bought mom's house and I bought it this way so that when she died, it came back to me. It was only fair. I paid for it, right? Oh, well, I helped her do the kitchen. Well, you know, thanks. But nonetheless, you know, it's an estate in reversion and it reverts back to me. Now, there's one more subcategory to life estates, and that's if I decide instead of it reverting back to me, that it would go to a third party, such as my children. That would be a remainder estate. Mom would have a life estate, and my children, we'll say children, and I'll write third party underneath, are the remainder men, the one that are going to be inheriting the property upon mom's death. Remainder man, third party. I could put children, right? Maybe I didn't know I was done having children when I bought this house. So that would be contingent. If I would have put, so I'm going to write here just the word C to remember contingent, or V for vested, where I would have put Jim, my son, Jack, and my daughter, Mary. I would have named them. They would have been vested. That is a remainder estate, goes to a third party. An estate in reversion reverts to grantor. I put reverts grantor. So when you guys go back and watch this. Now, both of these are created conventionally, meaning what do I mean by conventional? By man. One of them is also the legal life estate. What do I mean by legal life estate? Well, if the property was purchased in strivality, I'm going to use the same example. I'm going to use the same example I always do. So a gentleman has a baby with his college girlfriends. Things don't quite pan out. They don't work out. He gets his career going. He buys a nice house. And he gets to drink all the beer he wants, watches all the football games on Sunday, checking his fantasy football scores. He's got nobody telling him why he has to watch the 1 o'clock, 4 o'clock, 8 o'clock, and why he's going back and forth to the red zone and to the other game, and why he's had more than 6 beers. Hell of a bachelor pad, right? And, well, his son comes over every other weekend as well because, you know, family court is family court. And he gets to watch the games with his kid, barbecue, and have a good time. Somehow, he falls in love, marries this woman, and moves her into the house. The house is homesteaded. It's in his name. It's in servality. He has 2 kids with her. Guess what? At first she was cool. She'd watch the football games with him. But now she's like, why do you have to watch them all? And who cares about your fantasy football? And you've already had 7 beers. You can't have any more. So he decides that on football Sunday, he's going to go to the bar and have his beers there and watch the game. Well, one day heading back from the bar, maybe he had 1 too many and he hits a tree and he dies. What happens to the property? She gets a life estate, a remainder estate, and all of his children, the 2 he had with her and the 1 from the college girlfriend, are vested remainder. Does that make sense?
Yes.
Nobody liked the story though.
Kind of lost.
The story is the story got you lost?
No, with the vested and the wife get the house. So
Yeah. So it's in servality. She wasn't on title, but they got married. She lives there. It's a homestead. And he had a child before and 2 children with her. So operational law, unless he has a will, automatically she gets to live there for the rest of her life. And the day that she dies, it goes to his 3 children. And obviously his 3 children are vested, right? Because we know who they are, unless, well, he had another child with the bartender at the bar that we don't know about, but we can't speculate.
okay, so my question is, wouldn't it be like, well, with the first kid, wouldn't it be like they had to sell the house so they can like share the money, or what?
Yeah, once she dies, right?
Oh, only
then,
when,
go ahead.
I said, oh, only after when she dies. So technically the kids would not get anything unless she died.
Right.
A, yeah, you're right. That's the law. But B, anything is negotiable. Maybe she's like, I want half, and you guys, the 3 of you, can take the other half, and we'll sell it, you know, now. There's always anything can be negotiated, right? But by operational law, this is what automatically happens. Kids will then have fractional ownership. That's correct. They would be tenants in common at 33.3% each. Any questions?
I have a question.
Yeah.
Could that second wife before she dies sell that house and it still count?
Can she sell the house before she dies? No. That's an excellent question because I forgot to tie in my legal bundle of rights. I said fee simple has the full disposition, enjoyment, exclusion, possession, and control. Guess which one you don't receive when you receive a life estate? Which of the legal bundle of rights do you not receive?
Disposition.
Disposition. That's actually on the state exam. What's disposition? It's not only the right to sell, but it's the responsibility to maintain it debt free. Right? You got to pay the taxes. You can't mortgage it, etc. Because mortgaging would be considered disposition. That's on the state exam, guys. Any other questions on freehold estate?
And mortgage?
How would that question be like said on the test? What is the wife?
Here's how dumbed down it is right now. When a property is owned in servality, right? Does the husband, who has to sign the sales and purchase contract? Both of them. If the property is homestead and owned in servality, you need to know that she also needs to sign, because she will be relinquishing her legal life estate. That's how I hear it pops up on the state exam. Also, it pops up on the state exam as far as, in a life estate, which of the legal bundle of rights is not present, and you're going to pick deep C. You're going to pick the D out of deep C. Any questions on freehold?
I have
Go ahead.
I have a clarification, because there were a lot of questions based on this freeholder state on the exam. And my question is, if when they ask your questions and some of the answers, they do put like under freeholder state, they put like fee, wouldn't they put like fee simple, and then they put joint tenancy? Like,
Yeah, that's a great question. Yes, they love to do that. So we're going back to, maybe all the answers are correct, right? So here's what a question would look like. Brown and Smith own a property. Brown passes away and Smith gets Brown's share. A, is it a freehold estate? B, is it a fee simple estate? C, is it a life estate? Or D, is it joint tenancy? What would you pick? What's the most correct? It's joint tenancy. Even though it is freehold estates is both of these, right? Fee simple is, joint tenancy is a subcategory of fee simple, but the most correct is they want you to pinpoint exactly which one it is. You see what I'm saying? If joint tenancy wasn't there, then you're going to default to fee simple.
So wait, joint tenancy isn't only marriage? Like, there
No,
could be other-
no. Tenancy by the entireties is marriage,
Okay.
which has all of the same features of joint tenancy, for the exception that it must be a married couple and it's only going to be two people, right?
Okay.
But what they do is they see how I went subcategory into subcategory, where, yeah, a joint tenancy is a fee simple estate, which is a freehold estate. But if they give you enough information that you know it's a joint tenancy, you got to pick the most correct. That's the thing with this test, is that you have to pick the most correct. And sometimes, oh, hey, yeah, joint tenancy, this situation is fee simple, great. And you don't read all four options, the most correct answer is joint tenancy. The only one that I gave you that was wrong is that it's a life estate. Does that make sense? And as a matter of fact, that Brown and Smith question has been brought to me by two students. I don't know how they know the exact names and shit, but I guess now with the whole proctoring, you can shut off your computer and start writing things down quicker. So I've been brought more questions lately than I have when it was live, because when it's live, like I would have students, they have to wait on their thing to get printed out. And then I would tell them, hey, pull out the recording on your smartphone and start talking into it and bring it to me. They keep me on my tippy toes, right? Changing this around. Being that it now is online, they can literally just shut down the computer and start writing away. Anybody seen that question? And with those answers like that, right, where yeah, it is a freehold estate. Yeah, it is a fee simple estate. But really, the most correct answer is joint tenancy. There's a lot of questions there where there's two in left field, and you can pick between two. But a lot of their style is picking the most correct answer, right? And in this case, what you just had asked me is about the most correct answer, that you would pick joint tenancy, even though it is a subcategory of fee simple, even though fee simple is one of the freehold estates. Now, I want you to know, and we're going to see this in chapter 9, is the habendum clause in a deed tells you which freehold estate is being conveyed. So if it's fee simple, the deed is going to say, the habendum clause in the deed is going to say to have and to hold forever. Am I going to cover the legal bundle in more details? Which one of the legal bundles do you not understand? So for example, I'll talk about them quick. Disposition, again, I think I talked about that in detail. You can't sell, you can't mortgage, you can't not pay the taxes. Enjoy, your right to enjoyment. Right to exclude. If I give my mom an estate in reversion, she gets mad at me, even though it's going to go back to me the day that she dies, she can exclude me from coming onto the property. The right to possess and control. That's the legal bundle of rights. Now, disposition is really the one you want to know and tie into life estates. Fee simple, all of these on this side have the entire deep sea. Don't get confused because Jim, Jack, and Mary or whichever got left out. Eventually, somebody's going to have the right to dispose and enjoy. They all had the right to enjoy, exclude, possess, and control, but at some point, somebody's going to have the right to dispose. At no point in a life estate, the person that has the deed has that right. When it's concurrent and it's joint, they have the right. Yes, 4 questions like this. That's why I want to make sure you guys know this. You know, supposedly this chapter is only like 8%, but man, do they love to ask about these freehold estates. Non-freehold, not too complicated. I'm going to talk about it now without the slides. And I don't like using the slides too much for chapter 8. And then I'll just talk about personal property versus real property. Any questions, though, on freehold before we talk about non-freehold? Enhanced life estates have not made it to the exam yet. Let's not even go there, James. Yeah, just reversion and remainder. Any question, guys, before I change it up into non-freehold, which is, I think, rather easy. All right, so non-freehold estates. Non-freehold estates is simply a transfer of possession. Only you get title if you have a freehold estate. Non-freehold estate is a fancy word. Also, it's known as leasehold estates. Of course, you're not going to see leasehold because off the bat, off the rip, it's going to tell you that what you're dealing with there is tenants, right? The first one is an estate for years. An estate for years gives you a begin date and an end date, just like a lease would. You know, if we're involved, it can only be for 365 days, but you can have a lease for 5 years with a begin date and an end date. Not a whole lot to it. An estate for years, fancy word for a lease. The next one is a tenancy at will. We had a begin date, but we don't have an end date, such as a month to month. For example, with my tenants, I start with an estate for years. It's typical through the MLS. We sign for a year, and we'll say that the lease is up February 28th now, 2021, right? But when I went February 1st to pick up the rent, I told my tenant, hey, I'll see you in March. What did I do? I created a tenancy at will by using those words. Hey, I'll see you next month for the rent. if I don't use those words, and the last thing that and this is what they do on the state, because some instructors I've heard teach this, that it goes in order. It goes from estate for years to tenancy at will to then tenancy at sufferance. But if I went and I picked up the rent February 1st, and I don't tell the guy I'm going to see you next month for the rent, well, I'm expecting him to be out of there by February 28th, right? And if he's there on March 1st, what happens? It's a tenancy at sufferance. He's in naked possession of the property. He's there. He's not supposed to be there. But to go back to tenancy at will, if you have a tenancy at will, which you had the begin date but no end date, and either party wants to terminate, if you collect the rents on a month-to-month basis, you have to give them 15-day notice. It could be 15-day notice to up the rent, right? That's why I don't renew my leases, because if I wanted to up the rent, I don't have to wait a whole year. Or if I ever need the property back, I don't have to wait the whole year. If they ever start deciding to pay, on the 15th, I can just say, you know what, get out or I'll evict. Right now, we have an eviction moratorium, so if you're a landlord, don't be too much of a jerk. But I want you to know, if you collect month to month, 15-day notice. If they pay you week to week, 7-day notice. Obviously, I would never give somebody 15-day notice to move out of a house, but that's statute, guys. Any questions on non-freehold? Estate for years, begin date, end date, written typically, right? Tenancy at will, month to month. Tenancy at sufferance, an eviction in the making. The tenant's in naked possession of the property. He's there. He's not supposed to be. All right, I'm just gonna pull up the slides to go through real versus personal property, and wrap up with co-ops and condos, and we'll jump into chapter 9. Okay, I gotta pull it up. All right, guys. So real property is what the book always references. Real property is the land, which is Mother Nature. Then real estate is land plus human-made improvements, the house, the pool, driveway. And real property, as we've been referencing, is the Mother Nature, the man-made, and deep sea, the bundle you receive with ownership. Okay. Now, physical components of land. I want you to know that when you purchase property, you could be limited to what you can do on your property, but you truly own the surface rights, which includes, right, the land, the trees, rocks, and maybe some water. What's on the state right now is riparian rights. Piece of land that abuts a river is going to be riparian. That's on the state. Riparian is rivers and streams. Everything else is littoral. Ocean, sea, lake, bay, pond, canal. The rest are littoral. No riparian, that's what's on the state, right? Then you have the subsurface rights, right? You own your subsurface rights to literally to the core of the earth. Go ahead.
I'm sorry, can you please repeat riparian rights for me, please?
Riparian rights are rights associated with a moving body of water, such as a river or stream. Clear?
Yeah, would that be, I'm kind of confused between like the ocean as in like the beach type or the one that the people have behind the house.
Okay, riparian is rivers and streams. littoral would be everything else: ocean, sea, lake, bay, ponds, etc. No riparian, because that's the one they ask on. But littoral, if you had beach rights, right? And not many people do have really beach rights. You would have littoral rights. Make sense? So subsurface rights, also known as mineral rights. My right to underneath my property all the way to the center of the earth. Now, police powers, which we'll talk about now in chapter 9, may limit what I can do with that, right? It doesn't give me the right to drill for all of my property just because I own it, right? But I do, in fact, get it as part of the ownership. And then you have the air rights, which involve the space above to infinity. Doesn't give me the right to build a 20-story high-rise on my property, but I do, in fact, own it. And police powers is constitutional. It allows government to limit what you can do with your own personal real property. Here's the thing is, and I'm going to agree with you there, Mia. Yeah, tides, right, come in and out. They move. But rivers and streams move rather quickly. Just remember riparian river and a stream. Try not to overthink it. But yeah, I totally agree with that. All water moves. I live on a lake. 6 months out of the year, all the shit that's in the lake ends up in my property because I live at the end of it. I have a whole view of the entire lake. In the winter months, the people on the other end of the lake get all of the junk flows to them. So I'm going to agree there, but rivers and streams move rather quickly. Sometimes it is easier for guys, you know, if you fly fishing, if you're into fishing, you know, typically you fly fish in rivers and streams. But if you remember riparian river and tie stream into it, you're golden. The rest is going to be littoral if they throw anything else at you. But I'm telling you, I'm playing butcher here. I'm trimming the fat on the test right now. House abuts a river. What right do they have? Riparian. Trust me. Somebody unmute themselves or chime in here. Who's seen that question?
A question on riparian rights, yeah.
Yeah. Has anybody seen anything on littoral rights?
No.
No.
All right, so trust me, please. I feel like I wanted to get more done, and here we are. It's 4 o'clock. I got 2 hours to pound some math in. You know what I mean? I don't want you guys to overthink it, right? Casey, have you seen littoral rights, or you seen riparian?
I think it was riparian.
Right. I'm telling you, that's the question. A house abutting the river. The whole point of you guys joining me here is because I know what's on the state. I'm going to get you to pass. I don't want to kind of overthink or explain things that are not going to really help you with the state. But listen, I don't want to be a jerk about it, and I'm not trying to be. If you like, send me an email. We can have a chat, and I will, you know, explain to you anything you want to know for a personal level. But for the sake of the other 55 or 54 people here, let's get straight into me playing butcher and trimming out what you don't need, right? Accretion alluvian. You'll see that on the state. Accretion is action. Alluvian is the noun. Accretion is the process of land buildup due to waterborne rock, sand, or soil. So here in the Miami River, the mouth of the river forms kind of a beach, right? That's additional land, a little beach there. And that beach happens because of accretion. The sand is alluvian. What is being deposited there? If it was gravel, then the gravel would be alluvian. But the process, the action, accretion, action, and alluvian, noun. What is it? Don't worry about erosion, reliction, you won't see those. Now let's talk about the two basic property types. You got real property, which we already kind of spoke about, and now personal property, right? And we're going to talk about whether an item is personal or real, right? Real property becomes personal property by act of severance, right? So if I rip out a bathtub that was real property because I'm leaving behind damage, it becomes personal. Doesn't mean I can do it unless I have an agreement, right? Personal property becomes real property by attachment. And I want you to know that. A fixture was personal property, which is now real property. And we'll stick with the bathtub. The bathtub in its box that I buy at Home Depot, it's personal. I take it to the house, I leave it in the garage for a week or two. As long as it's there in that box, it's personal property. The moment I install it and now I tile around it, I grout it in, it becomes real property. So know the definition of fixture. Was personal, now real. Now, we covered number 4 here, method or degree of attachment, right? If ripping it off causes damage, then it's going to be real. Just like ripping out a bathtub that was there, ripping out kitchen cabinets, right? Things like that. I will tell you that the fridge, the stove, washer, dryer are not fixtures. They are personal property. If you can unplug it and just wheel it out, it is considered to be personal property, or also known as chattel. Okay? So let's go back to number 1, intent of the parties. Intent of the parties is easy. You probably won't see it on the state, but I want to harp on it because once you get going in your career, the intent should be spelled out in the contract. Right in the contract. If you see a fancy chandelier in that dining room, write down chandelier in dining room and maybe take a picture of it. Because I've had nightmares with agents of mine where they go, they do the walkthrough, and all the nice fans and all the nice chandeliers are gone. And guess what? They replaced them with the $5 globes from Home Depot. So be careful with that. Put it in the contract. That's the best way, so you don't have to go to any of these other tests. Now, relationship or agreement of the parties. In this case, we're talking about a landlord-tenant relationship in a commercial space, right? So the whole method or degree of attachment goes out the window when it's a landlord-tenant in a commercial space, right? If I need this for part of my business, it's considered a trade fixture and I can take it. There's 2 examples on the test with trade fixtures. A, the big metal racks that an auto parts store has that are affixed to the foundation with big bolts that, you know, removing it is going to leave these holes in the foundation. You can take it because it's part of your business. Second is the dentist chair. Dentist chair uses a 2-inch large nut, you know, driven in 6 inches into the foundation of the office space. Can he take it? Yeah. Pieces up. It's a trade fixture. Dentist needs his chair. No matter what, he can take it. If you've ever walked into a vacant retail store where they use pegboards to like hang up, you know, clothing and things like that, those little pegboards with the brackets on them, oh boy, does that leave those that drywall riddled with little holes. And then lastly, guys, adaptation of the item. Is the item made specifically for that property? For example, if the curtains match the wallpaper, curtains must stay. Be careful with curtains. Curtains is one that I've been a few times had my buyer screwed out of and had to help them pay for some curtains. So I started now writing curtains into the contract. They can't take the rod holders because if they took the rod holders, well, it would cause damage. But the curtains, you can just pull the rod out, unslide them, and take them. So intent of the parties, the contract is the most important, but again, it's not very important for the state. Now, adaptation of the item, as I know it on the state exam, is a pool screen enclosure, those little cheapy pool screens that you kind of drill a hole in and you place in the hole and you can just kind of pull it up and take it out if you have a pool party, right? Because now in the South Florida building code to protect toddlers, everybody must have some sort of pool gate, and the cheapest rod is usually to get those screens. What are the odds that you can take that screen, right, and take it and put it in another property? First off, maybe you put it 1 inch away from the lip of the water. Maybe somebody who had, by coincidence, the same exact pool with the same dimensions, did it 2 inches away from the lip. It's impossible Not near impossible, but it would be impossible for you to take that screen pull gate and take it somewhere else and it would fit exactly. So therefore, it stays, and that's what's on the state. All right, so we talked about all this. I want to end chapter 8 with co-ops and condos. Co-op, we talked about apartment buildings, right? A co-op is a multifamily apartment building owned by a corporation. We'll say Sunnyside Villas LLC owns this building, right? And the owner wants to turn it into co-ops. You're from New York, you know exactly how this works, because they're a dime a dozen. Here you see some on South Beach and some in Bal Harbor, but they're not very common. So to keep this simple, Sunnyside Villas LLC is an 8-unit apartment building, which is now converted into a co-op, and 8 times 12.5 equals 100. So we're going to say that all 8 units are the same. None is more lucrative than the other. None has a better view. None is any bigger, right? Just to keep this simple. The owner of Sunnyside Villas is going to sell 12.5% shares into Sunnyside Villas, and that's how you own into the corporation. But just because you own shares into a corporation doesn't necessarily entitle you to occupy real estate per se, right? I own a boat, you know, I invested more money than I probably should have, even though it's recuperated in Aurora Cannabis, thinking they were the next Budweiser of pot, and because I own a bunch of stocks there, doesn't give me the right through when I'm passing through Aurora, Colorado, that I'm going to say, hey, I'm Jose, I own $25,000 worth of share in your company. I'm sleeping in the lobby tonight. So just because you own shares doesn't give you the right to occupy. This is what's on the state. What gives the shareholder the right to occupy the unit and not just be a shareholder is known as the proprietary lease. That's on the state. Know that the proprietary lease gives the stockholder the right to occupy. Condominiums, we talked about the time frames, right? 3 days resale, 15 days for a developer. What I want you to know about condos is the common elements, right? Let's say Sunnyside Villas is not a co-op anymore. It's an 8-unit condo. All units are the same. So you're now 12.5% owner. You have a deed for your unit, but the 12.5 kicks in with condos too. Why? Because that's your fractional, undivided ownership of the common elements. What are the common elements? The pool, the green area, the park, anything outside of things like the parking spots, right? Because the parking spots are assigned and they're actually deeded. They're called appurtenances. But I want you to know that whatever your ownership is, if you live in a condo, open up the condo docs and usually unit 101.0, because obviously I'm making this simple by telling you that all 8 units are the same and it's a very small condo, right? Usually not the case in real life. Now, I want you to know the documents that must be given, right, when purchasing in a condo. These 4 here have to be given to both new and resale. The declaration, the articles of incorporation, the bylaws. You want to know the bylaws is the one that ties into the 3 and 15 days. That's state exam stuff. And then when you buy from a developer, prospectus is on the state. If there's more than 20 units, you have to get a prospectus. There's also a question, if there's more than 25 units, then it could be a property report.
Is there any way that you can go back to the condo documents?
Sure.
Thank you.
Any questions on those? I want you to know bylaws. The bylaws is the rules and regulations. That's what you're going to read. Hey, can I have a dog here? What time the pool closes? Things along those lines.
Now, as far as if it's a new construction, is that the prospectus And if it's like an existing one, you get the like the profit and loss or the operating budget from the previous year.
Well, with the new, you get a prospectus if it's more than 20 units, and you get an estimated operating budget, right? Which is usually very conservative when you're buying new. When you're buying resale, right, you're getting the last years, the most
there you go.
recent year ends. So you want to know those two differences, right? And then the governance form. This pops up on the state. The governance form is where the board of directors, right, the president, vice president, secretary, treasurer, each condo has a different type of government setup. In this case, they have to give you, just like the title company, their name, their address, and their telephone number. Guys, that is chapter 8. I don't cover timeshares. It's not really on the state. Any questions on 8? Guys, I know I'm going through this quick, but remember, you have the recording. If you're taking the test tomorrow, watch it again tonight. What I'm trying to do is give you as much information as possible. Even though I'm going to send you 20 math questions, so I'm not too crazy about if I don't do so much math with you today, because the 20 math questions that I'm going to send you guys is, question A, B, C, D. You try to do it, you get it wrong. Then you go to the answer sheet and you click a link, and it'll take you to a YouTube video that's hidden, and it'll watch, you can watch me work it out. But we need to do 9 and 11, and then 11 is 12%. 9 is also a very difficult one. 10, a little bit of the math there, right? And 12 and 13, I want to talk about theory and the math in there. But I don't want to feel like I'm rushing anybody, right? I don't want anybody, feeling uncomfortable about my pace. Slow me down. It's fine. I just, really rather stick to what's on the state exam. When you take this cram, I assume you really took the course somewhere. And I know not everybody probably had the best experience. Some of you may. How many of you bought the Azure Tide? Tell me if you did. Or real estate.
I did.
Yeah, man, you pay for what you get. At one point, the owner, which is some lady, had a fight with the person that put the thing together for her, and the lady sabotaged, and there was nothing but erroneous information there. About $30 on Groupon, you pay for what you get. You know what I mean?
She does do the Kemper lady. She does the Facebook lives where she does like additional study sessions. But yeah, you're right. It's up to you to assimilate it.
Yeah, I mean, and at the end of the day, okay, that's Julie. That's a good definitely feedback that I'll take into consideration. I just find that the book kind of jumps around a lot, and if you notice the way I lecture, I can't always use the slides. I feel sometimes that the whiteboard is way better. Like I want to show you something real quick before we go into chapter 9. All right, for example, and these are Dearborn slides, sure. Should I eventually put mine together? Certainly. But here we start with estates and tenancies, right? Basic property rights. And then freehold estates, talks about the two. Fee simple. Then jumps to life estate. Life estate, it gives you both. Talks about the legal life estate. Then homestead. And then it goes to non-freehold. Then you go through all the non-freeholds before it goes back to the other freehold estate. So, sometimes that's why I don't use it. Sometimes, yes, you're right. I get ahead of myself. I have this, sadly enough, the knowledge of this entire book in my head. But the knowledge that I'm giving you is really what's on the state, and that's kind of what I want to stick to.
No, I was referring to like the slide on the condos and because we had timeshare up when all the talk was just going on. And I was just trying to talk, copy down about the governance and stuff. So I meant just the previous slide before we, instead of looking at the timeshare one, when everyone was talking. That's what I meant.
Were you looking at the timeshare ones? Because the timeshares,
That was what was up on my screen when everybody started talking just now. And I was kind of hoping that we would have left the condo up so I could, pay more attention to that, because I know you said the timeshare's not on it. But that's what I was seeing on my screen when everyone was just talking. I don't know about anybody else.
You were looking at this?
This or some other timeshare screen. This is one of these. I wasn't paying attention to the condo, because the timeshare, because you said it wasn't on the test.
Okay.
So that's what I meant. I was trying to pay more attention to the condo slide, and it switched to timeshare, and then everybody started talking. So I was just kind of hoping you to flip back to the condo so I could write more stuff down while they were all talking.
But you are going to email this to us, right? So
I'm emailing this to you guys.
Right.
Yeah. Oh, I know, but I like constructive criticism, right? Like, it's
Absolutely.
I can always improve, on my teaching methods. So I appreciate that, Julie. Nonetheless, why don't we go ahead and just take a quick 5, and we'll get into chapter 9.
Thank you.
You're very welcome. All right, guys, I'm back. I had to go to the bathroom real quick. Let me pull up chapter 9 so we can go through that. Sure. All right, chapter 9, legal versus equitable title. I want you to know, this is on the state, that legal title is nothing but a concept, signifying an ownership to a collection of rights called the freehold estate, which we just went over. There's two types, right? Fee simple estates, life estates, and we talked about their subcategories, right? So it's nothing but a concept. What transfers that concept is known as the deed, which we'll talk about now. Equitable title is the interest that implies that you will be receiving title at a future date. And I'm going to tie this into mortgages now. We already talked about the promissory note and the mortgage and how those work. Now I want to talk about theory. There are two types of theory in mortgages, lien theory and title theory. Florida is a lien theory state, but believe it or not, they love to ask about title theory states, and the majority of the states are actually title theory. So if you bitched and complained that the bank owns your home, or you feel that way here in Florida, if you lived in a title theory state, literally the bank owns your home, meaning that the mortgagee, which is the lender, right, has the title to the property. They have the deed. So if you looked up in a title theory state, in public records, ownership, Citibank will show up as owner, etc. Now, in a title theory state, again, the mortgagor has equitable title, the mortgagee has the deed. When the mortgage is defeated under the defeasance clause of the mortgage, it prompts the lender to turn equitable title into actual title. And when is the mortgage defeated? When it's paid, right? Now, alienation is the act of transferring ownership, title, or an interest, right? If you're a tenant in common, you may have a small interest, but this is how we part with real estate, right? And it can either be voluntary or involuntary without the owner's consent. There are only two forms of voluntary alienation. And the first one is the deed. The transfer deed is obviously voluntary. The grantor is the only one that needs to sign the deed. The grantor signs, it is voluntarily delivered and accepted. Does the deed need to be recorded? It does not. Okay, there's a lot of things that if you have some knowledge of real estate, you're going to believe have to be done. A deed does not need to be recorded. The second form of voluntary alienation is a will. When somebody dies testate, they leave behind the will. Okay, and in this case, it was obviously done voluntarily. Upon their death, they controlled where the property is to go. Now, a testator is a male who leaves a will, and a testatrix is a female who leaves the will. And I want you to write this down because it's not really in the book in this fashion, but you're going to need to know it for the state. Graham Paul, the testator, left his device with one E, which is the house, to the device C, his grandson. So one more time, Graham Paul, the testator, left his device his house to the devisee, his grandson, sorry. Any questions on that? All right, no questions. So now let's talk about involuntary alienation. A property is transferred without owner's consent. The first one is descent. And I want you to write next to descent probate, because basically the judicial process is known as probate. When somebody dies intestate, their heirs come forward in a probate hearing. They are appointed a personal representative and are given a personal representative deed. So I want you to know, die intestate, heirs come forward, probate, personal representative deed. Now, if somebody dies intestate and no known heirs come forward, that's cheat. It goes to the government, right? No known heirs come claim the property. It's all in the word. It's cheat. The government takes it. And then don't worry about adverse possession, eminent domain you want to be familiar with. Eminent domain is actually constitutional. It's in the Fifth Amendment. The Fifth Amendment gives me the right to not have to talk, but somewhere snuck in there, it says that government cannot take private property without just compensation. Now, in order for government to take property, it must be for a public purpose, right? For public use. The process, the judicial process, is condemnation. So you're in the middle of a road expansion. Your farm that you live on has been in your family for the last 150 years. Your only recourse is to request a condemnation hearing to contest how much you're getting paid. That's it. You're not going to put a stop to it. If the government needs it, they're going to take it. Any questions on this? Why does a deed not need to be recorded? Because of actual notice, because it's been witnessed. Constructive notice is recordation in public records. Chain of title. This is on the state exam, by the way, guys. Chain of title, what is it? It is a complete history of the owners and encumbrances. That's how it pops up on the state. In all reality, a chain of title is almost impossible to do in Florida. I mean, if we were to do one, we would track basically real estate back to when King Ferdinand of Spain sold Florida to the United States, right? So what's typically done is an abstract of title. An abstract of title is a condensed report of what would be using public records going back 30 to 40 years. This is the due diligence that an attorney or a title company would do before issuing title insurance. Is title insurance mandated in Florida? Anybody want to tell me if title insurance is mandated? That's on the state.
Gonna say no.
It is not mandated in the state of Florida, right? Because if I quit claim deed my property to my kids, why are they going to go out and buy title insurance? I want you guys, again, I think I mentioned this earlier, don't think about how you're going to be working and selling property, right? There's a lot of intra-family sales, a lot of real estate transactions that are done without assistance of real estate agents, right? The next thing you'll see here is opinion of title. It's on the state. Do not give ever opinion of title. A broker cannot prepare a deed. That's on the state exam. An opinion of title can only be rendered by an attorney, right? This license doesn't give us the capability, the know-how on how to give an opinion of title, right? It's like a nurse can't perform surgery, but a nurse can pass the scalpel, right? So refrain from giving opinions of title. If you do, what would it be a violation of? Is that a rule or law? Is there a potential victim? Is there a victim? Certainly.
The buyer.
Yeah, you tell the buyer, yeah, the title's good. And it's not. And now 60 days pass by and they find that there's, clouds or encumbrances on title, and you could be victimized by it.
So who would declare that there's no clouds on the title?
Attorney or the title company. And opinions of title are only to be rendered by attorneys. Like, I've bought property in the past at auction. I, look down the list of what's going to be auctioned off, and I would have my attorney, look up the title for me and tell me, hey, this one's good, this one's got a HOA lien on it, or whatever it may be. I've heard horror stories of real estate agents, and you see this in front of FREC too, which have actually charged to take their customers to auction to buy property, and guess what they bought? They bought an HOA lien. So there's still a mortgage on the property. They bought a junior lien, which we'll talk about later.
But anyone can check a chain of title. That's public record.
Well, a chain of title is pretty much a complete successive history. You're not going to find that in public records of all of the owners, and remember all the encumbrances. That's on the state exam. An abstract of title, again, is a condensed 30 to 40-year history searching public records. And believe it or not, here, even in Miami-Dade County, and I'm going to talk about Miami-Dade County, it isn't even the most accurate, because during Hurricane Andrew, the South Dade Justice Center was literally destroyed. And when they used to file paper before they started scanning it and putting it in, computer base, were lost, destroyed. So, but again, it's the due diligence that's done before issuing title insurance. Now, title insurance is not required in Florida, but if you're going to obtain a mortgage, the mortgagee is going to definitely require you to buy it, right? It's a good idea to buy it, but you don't have to purchase it. Okay? Now, title insurance is the only insurance that I'm aware of that will cover the policyholder from the moment they purchase it into the past. Okay? There are two different policies when you buy title insurance: the mortgagee policy and the owner's policy. I want you to know that the lender's policy, which is the mortgagee, is transferable. Why? Because if you've had a mortgage, you know that when you get the mortgage, ABC Bank services it, and then 4 months later, now it's Citibank, and so on and so forth. And it's transferable so that it permits them to sell these servicing rights. All right, deeds. Grantor gives grantee money, okay? Let's talk about parts to a deed. The first one I want you to know is the granting clause. That's on the state, which is the only clause that a deed must have. The granting clause, because it contains the words of conveyance. And what does a deed do? It conveys, it transfers. So if there's no granting clause, literally there is no deed. I mean, the other clauses are rather important, but that one's the most important, because without it, there's nothing being transferred. I talked about habendum, right? The habendum clause tells me which freehold estate is being conveyed. To have and to hold forever, fee simple. Life estate would be, it would say for the life of. Now, deed restrictions. Any grantor can enter a deed restriction in a deed. Once they enter it, they can't remove it, because they're selling it at that point. the grantor entered it, it's done. The question on the state exam with deed restrictions, if you've seen it, is how can a grantor control what happens to the property after they sell it? By entering a deed restriction. You could put on the deed that this property cannot be built on for the next 50 years, that you can only build a one-story home, that you can only build, residential on this land, pretty much anything as long as it's not illegal. Then we have the appurtenance section. The appurtenance is where that parking spot's going to go to in your condo, right? Ownership, that's not necessarily attached. It's like an ownership interest that you have. It does belong to you, but it's not physically part of the land or the real property. For example, a boat slip or the utility closet in a condominium, right? All of those would be considered appurtenances. Now with the deeds, I'm going to go backwards. I'm going to start with the general warranty deed. This is the most commonly used deed. It is the most advantageous from a grantee standpoint because the grantor promises to defend the title forever. I mean, what does that mean? It could be limited to him tracking down the person who sold him the house, to try to track down maybe a missing signature somewhere up, the ladder of conveyances and transfers. It is the type of deed that is to be used if no other is specified. Okay. Now, this deed also has the Sison clause. The Sison clause always pops up on the state exam. The Sison clause says, I own it and I can sell it. This is the promise you're making, right? That you own this particular piece of property and that you have the right to sell it. Deed fraud is something that's a rather big issue in South Florida, right? Fake ID is all you need, or I've seen where, Junior, that has the same name as Dad, sold the house when Dad was in prison once. They violated the Sison clause. Deeds are recorded. They don't have socials. They don't have fingerprints. They just have a name. If you have a common name, like I do, be on the lookout and ensure that there's nothing going on from time to time by checking public records. Now, general warranty deed is warranty forever. Special warranty deed is where the grantor says, well, I will give you warranty while I was owner, but I can't vouch for what the person before me did, right? This is usually used by lenders when they sell their foreclosed assets. I just foreclosed on this guy 3 months ago. I'm selling it now. I don't know if he went out and got a second mortgage on it that hasn't been recorded. So we haven't done anything, but we can't vouch for the person before us. Then you have bargain and sale deed. And pretty much this is like, don't come back and see me. I'm not giving you any warranty. It's kind of like as is, where is, and these are used at auction. What you're buying is what you're getting. If it has liens or not, I'm not going to help you clear it. And then lastly, I want you to know quick claim deeds. How much is this on the state exam? Well, chapter 8 and 9 are 17 combined. Quick claim deeds, the only thing I want you to know, and this is on the state, is I want you to know that it's used to clear clouds on title. Okay, they like now to ask also about these special purpose deeds. Give me 1 second, guys.
What are clouds?
What are clouds? Sorry, guys, been a little under the weather. And I just had to blow my nose. Didn't want to do it with the mic on. Clouds on title are issues on title, like a missing signature, they are hard to remediate. Where an encumbrance is something usually that money will make go away. An encumbrance can be an easement, like you know, something that is, we'll say it's kind of a headache, you know, because you have to allow certain people to cross through your land, or you have to allow FPL onto your property, but they don't affect transferability where a cloud would. Okay, cloud could be again a missing signature by a grantor somewhere, you know, in the past. Now, I want you to be familiar with personal representative deed. I already talked about this, right? Probate, they die. Okay, intestate, heirs come forward, probate proceeding, personal representative deed. Hopefully you get this question, the guardian's deed. This is an easy one. It is on the state, right? A guardian's deed is given to a minor who inherits property, for example. I want you to know the first two. Now we're going to talk about government restrictions on ownership. And I kind of brought up police powers over and over, right? Police powers is what the government can do to limit what we can do to our property, right? So if zoning or the building code says, hey, you can't go any higher than 2 stories, I can't go any higher than 2 stories. You can't drill for oil on your land, right? You can pretty much narrow this down to building and zoning department, right? They're the ones that enforce and pretty much fine and deal with police powers, right? Then we have eminent domain. We talked about that, right? Just compensation. It's constitutional for public use. And then, well, you never really own your house outright. If you don't have a mortgage, well, you still have the thieves taxing you, and taxation is theft, and therefore it's a government restriction. Now, private restrictions on ownership. We talked about deed restrictions, but on the state, they also talk and ask about restricted covenants. Restricted covenants is a type of deed restriction which affects an entire community. It is recorded with the plat map. We're talking here HOA, guys, right? I think the question is, what would not allow somebody with a plumbing truck to park their truck in front of the house? And that would be the restricted covenants, right? Certain communities don't allow for commercial vehicles to be parked in the property. Restricted covenants can be that you can only choose from certain colors of paint, that your garage can't face the street, things like that. Now, easements. It's nothing more. It doesn't transfer ownership. It is the right to use a portion of an owner's land for a specific purpose. Now, I'm going to start with easement and gross, and I'm going to go back to appurtenant. An easement and gross, you may want to write down, it's also known as utility easement, because they'll use the word utility easement on the state. And this is what allows FPL, Comcast, Florida City Gas, depending where you're at, to come onto your property to service their lines, right? It's usually up against the back portion of your property. It also says it benefits an individual, but let's go with business entity for the state, okay? Now, an easement by prescription, this is on the state. It talks about a guy who drives through somebody else's land and he's been doing it for 20 years. It doesn't give me enough information to tell me that why he's driving through there is that he's landlocked. But it does tell me he's been doing it for more than 20 years. He may be driving through that person's land to get, I don't know, to the lake, to go fishing, to get to the forest, to go hunting. He may be driving through that person's property for the last 25 years to get to his other buddy's house or whatever it may be, okay? Anytime you use somebody's property for more than 20 years, it automatically becomes an easement by prescription. For a long time, and this may pop back up on the test, maybe it is on there now, they used a group of homeowners that lived across the street from the beach, And they've been accessing the beach for the last 25 years through the hotel across the street's boardwalk. Well, recently, the hotel changed ownership and they have decided to put a gate on the boardwalk so that the homeowners across the street can't access the beach. What would a judge decide? A judge is going to decide that it's an easement by prescription. Okay. And then lastly, you have an easement by necessity, common in more rural type towns where usually dirt roads are private property, and if you're using that dirt road, you're more than likely driving through somebody else's private land to get out eventually to a municipal road, such as a state, county road, maybe it's a federal road, etc. And then I want to go back to easement appurtenant. An easement appurtenant is any time you use an adjacent parcel of land. So for example, I have parked my car on my neighbor next door's land in the front for the last 20 years. Now, after 20 years, he's decided because my cat ate his bird that he doesn't want me to park my car there anymore. Can he stop me? No. What easement do I have? I have an easement by prescription and I have an easement appurtenant. Why is it an easement appurtenant? Because he's adjacent. I did it for 20 years. I parked my car there, uninterrupted. He allowed it. He got upset after 20 years when my cat ate his bird, but it's also an easement appurtenant because he happens to be next door. I'm going to pull up a question from the red slides, guys, and I want you to kind of read them. Read this question and tell me what you think. All right. Number 58.
I'm sorry, what number again?
58.
Thank you. Mia, these are a little bit more convoluted than what's on the state. They've dumbed it down. I do have 120 questions and answers that I sell for $30 that are just kind of like the ones that are on there right now. There is a lot on the red slides that is on the state exam, but not I put together a whole new one, and I'm going to send you guys the math one for just being patient this morning. The math aspect of that one. Good. Most of you guys came in with B. It is an easement by necessity. And since Hubert, he's driving through Hubert, who lives next door, it would also be a pertinent. Yeah, I can go over all of that, Mia, when we wrap up today on the questions and answers. For example, some of you bought these when you bought on my website for only 10, but I sell them for 25. I still have to send them out to you. If you bought on Eventbrite and you want to buy these for 10, I can sell these for 10. The really good ones are $30. My students already have them as part of their course. But if you're interested, when you email, just let me know. You can go to my store and look too. I have like the whole entire, all chapters in detailed. For example, if you're not taking your course this week and you're going to take it in a few weeks, and you did one of those Resort Tides or Real Estate Express, I go through it a lot quicker. It's not a cram. It's actually, you know, very detailed oriented. Cram is, you know, you're almost there. You're getting that 65 to 70 something, right? All right, guys, so let's go back into chapter 9. Where are these? Let me close out some of these slides. That's my problem here. One second. Ariana, yes, exactly. Those are the ones I'm talking about. You'll get the math ones for free. It gives you a video explanation and everything. The other 100, there's 20 math. The other 100 are what's been brought to me lately from the state exam, and you get an explanation on why it's the correct answer. And you can buy them on my store, yeah. But let's keep rocking and rolling with the content here. All right, types of leases. I want you to know gross lease is where the tenant pays a fixed amount. So for example, I rent out my condominium for $1,800. I pay the taxes, I pay the condo fees, and you pay me that, just a fixed amount. Now, a net lease, and you want to write down triple net lease because that's how they'll put it in the state exam, is, and let's keep this simple, 4 base shopping center, all 4 units are the same size, 25% each. So each tenant is going to pay 25% of the taxes, 25% of the insurance, and 25% of the maintenance. Triple net. Maintenance is grass cutting, trash pickup, maybe security guard, etc. Then I want you to know ground, and I'll go to variable after I'm done with ground. Don't worry about percentage lease for the state. A ground lease is typically like the gas station, McDonald's, Burger King's in a shopping center. They're out by the road, right? What they'll do is they'll rent out the land for 99 years. Ground lease is also known as a 99-year lease. And in that case, you come and you build your own gas station. You come, you build your own McDonald's. And on turn, I promise to lease you the land for 99 years. Now imagine I got into one of these in 1985, right?
I'd be paying peanuts by today's standards. So these are variable, meaning they're tied to an index, and in particular, retail would be tied to the CPI, the Consumer Price Index. As that goes up, they usually visit it every year, so does the increase in the rent. Does that make sense?
Is there a question like this on the test? In ground leases?
On ground leases, could be, hasn't been brought to me. It was brought to me earlier. They're constantly changing it, but they also recycle these questions. They'll pull them out, they'll pull them in. For example, there's a contradiction on my red slides and the 120. Why? Chapter 10, real quick. The meets and bounds description uses inconspicuous markers such as trees and rocks. Meets and bounds description is the oldest, but it's the most accurate. Here's the thing is the question now is, by today's standards, what does the meets and bounds description not use? And that's going to be trees and rocks, inconspicuous markers. Even though they used to, they kind of flipped that one around. Now, by today's standards, they don't do that, right? By today's standard, they put a brass stake. But I'm going over stuff that I know that has been on there. I could tell you that it could be an option as well, and you want to stay clear of it. So know it. Then the last thing I want to talk about in Chapter 9 is lien priority. This is what they're hitting on now when it comes to liens. So I'm just want you guys to picture some sort of royal feast, right? Medieval times. And in this case, who would eat first? The king, right? Property taxes are king. They get paid first no matter what. Special assessments are the queen. They get paid second no matter what. Then you have the death tax. We'll say it's the princess. She eats third no matter what. All of the other liens, which happen to be non-governmental, coincidentally, right? The monarchy puts themselves first. They get paid in the order of which they are recorded. So we'll say that they're peasants. So after the royalty eats, in the order of which they line up, meaning in the order of which they were recorded, typically the mortgage is going to be the first one in line as the peasant is going to be the first junior lien. Any other liens after that would be, you know, in the order of which they were recorded. If you get a judgment lien, you get sued by somebody and they lien your home, well, depending on the date of when they liened it. Now, this is how you're going to see it, right? For example, what is the first lien to get paid? A mortgage from 2012 or taxes from 2018? Taxes from 2018 always get paid first. All right, no, don't worry about the dates. The superior 1, 2, 3 get paid, ignore the dates. Taxes first, special assessment second, death tax third, then after that, the dates become relevant.
What is construction liens considered?
Okay, the construction lien, also known as a mechanics lien, that's a good question. Those are retro dated to the date when materials were first delivered to the property. So for example, I hire a pool company to build a pool on my property, and the day the excavator was dropped off there, if I decide not to pay them their last payment, for example, the date of the lien would be the date that that excavator was delivered, not the date that I told them I'm not going to pay them.
But property tax would still be first.
Oh, absolutely. Property taxes are king. Property taxes from last year trump anything. Government comes first, guys. They put themselves, who writes the law? The government. They write it to benefit them. I don't want to go too much on a political tangent here, but if you believe that you are or we are the government, no, we're not. The government doesn't work for us. They work for themselves.
Bunch of crooks. That, guys, is chapter 9. I've been drinking water like crazy. Believe it or not, I got to run back to the bathroom. It'll be like 4 or 5 minutes, and we will go into 11. I'll give you 11 for about 30 minutes, and then I'm going to use the last portion for math. You're getting those math questions with literally video lecture, but I still want to go over some of the math live. All right, so let's just take a quick 5. We'll go to about 6. If we have to go a little over, that's fine. Yeah, I can repost it now real quick. Here is my, and I'm going to put it in, again, this is my email address. Any questions? You're going to request the recording and the slides, right? I'm going to send you in the 20 math questions. Let's take a quick 3 or 4 minutes. I'm just going to run to the bathroom. All right, let me go ahead and pull up chapter 11, 12% of the state exam.
While you're pulling that up, I have one question. Which should we buy for the $10? Should we buy the real estate exam questions or do we buy a different set of questions at the end?
The red slides, right? Those, if you purchased it on my website, you had the option to buy them for 10. Some people bought them, it wasn't downloaded. Those people are going to tell me, hey, I bought the Q&A. I can look it up. I'm going to send it to them. If you want to buy it for the $10, I can invoice you for those $10 to give you the same benefit that those that purchased it.
Is that the same as the one on your website that says new real estate exam questions, or is that different?
No, that's different. The $30 ones, I put a lot of manpower into those in the last few weeks. If you guys want those, you can pay for 30. You're already getting all of the math that's in there.
Okay.
I have a quick question.
What's up?
My exam is in a couple weeks, and you said something about having it, a shorter course on your website. Is that the 63-hour course?
The condensed 63-hour course, yeah, where you can listen chapter by chapter at a slower pace.
Yeah, I might do that.
The cram is literally for, okay, you've gotten a 60 something, high 60, 70 something, and you needed this final push. I'm telling you what's on there, and that pushes most people over. After I do this every week, I get like 8, 9 text messages. Thank you. This is what I needed, blah, blah, blah. If you haven't picked up the book and you're one of those, you took the COVID break and you haven't done this for a while, this may not be sufficient. I'm just going to be honest.
No, this is helping. I'm trying to pass the first time, so I'll just take everything I can get.
I hear you. I'll tell you, the 30 questions, the $30, the new question Q&A is like.
Yeah, I did buy that. I have to go over that. Yeah.
The students have told me they're like, oh, they've seen anywhere between 20 to 40 questions that were like spot on there. That's quite a bit. You know what I mean?
Yeah, I'll definitely review that.
Can I just ask you something quickly? I'm sorry, before we move on. Right before you ended chapter 9, you mentioned, if you can just give me the answers again, or just one answer. By today's standards, what is it that we don't use anymore for the meets and bounds?
In the meets and bounds, you don't use inconspicuous markers such as trees and rocks.
Okay, thank you. Sorry about that.
No problem. All right, guys, so chapter 11. This is the meat and potatoes of chapter 11. Colic. These are the essential elements of a valid real estate contract. First, you have to have competent parties. There's 2 aspects to competent parties. The INs, insane or intoxicated, make the contract void, right? Now, the other aspect is a minor contracting with an adult. In this case, the contract is voidable, and it is voidable by the minor. The minor can choose to force the adult to contract, but can at any point void the contract. Okay, so that's competent parties. The next one is offer and acceptance. In order to have a valid real estate contract, you must have offer and acceptance, and it must be of free will. There must be a meeting of the minds, meaning there was an offeror and an offeree, and it was free will. Nobody was coerced. The word they use on the state exam is duress. If somebody is under duress to contract, that means they are being coerced, forced, blackmailed, etc. Okay. Legal purpose, not a whole lot to, I wouldn't worry about that for the state. Now, the next one, in writing and signed, is important. The statute of frauds, what it does is it's intact to prevent fraud, right? Making certain contracts actually be written and signed. And those contracts are as follows. Purchase and sale contracts, option contracts, deeds and mortgages,
are instruments and conveyance, right? Lease agreements and listing agreements for more than 1 year are covered under the statute of frauds. They must be written and signed in order to be enforced.
What was the first one that you said? It was before option contracts, the purchase something, purchase price something?
What was that? Break it out.
Before you said option, the very first one you said that has to be in writing?
The purchase to sale contract, meaning a contract between the seller and buyer to purchase a home. Must be in written and signed to be enforced. Right? When I mean enforced, meaning in a court of law, it must contain the essential elements.
Is there a difference between enforceable and voidable?
Yeah, if it's void or voidable, it would be unenforceable.
It's like with
Okay.
Okay. Now, yeah, if the minor decides to void it, right, it's voidable, it would be unenforceable. If he decides to force the adult, then in this case, it's enforceable. The next one is lease agreements and listing agreements for more than 1 year must be in writing to be enforced. Now, if it doesn't meet the essential elements, and the statute of frauds being one, you want to know this, we're going to go back to, I went backwards, sorry. Went too far. The last one is consideration, right? Valuable versus good. Valuable means the consideration given is of actual value, money. Good consideration would be based on an emotion, such as love and affection. I'm not going to ask my daughter for a deposit on a contract because I love her, right? I had talked about earlier, my neighbor too, because I trust him. He's a good person, etc. Now, statute of limitations, which go hand in hand with enforcing contracts, are 5 years written, 4 years peril or oral. Okay, so this is how long these contracts, if they meet the essential elements, can be enforced in court. Now, this should tie it up or tie it all together. Unenforceable. What makes a contract unenforceable is a contract that will not be enforced in court because it does not comply with the statute of frauds and or, in this case it could be and or, exceeds the statute of limitation. Make sense? Everybody with me?
Yes.
Perfect. All right. Formal versus informal. Not a whole lot to this, right? Formal, written, informal, oral. You do want to know bilateral versus unilateral. Bilateral is where two parties are obligated to perform under the contract, and unilateral would only obligate one party to the contract, right? So I'm going to give you an example, and it's non-real estate related. Sometimes you see it this way on the state exam, right? And the example goes as follows. If a manager of a used car dealership offers a $5,000 bonus to the first salesman this month to sell 7 cars, what type of contract is it? Bilateral or unilateral?
Unilateral.
Uni, right? Because it only obligates the manager to pay the bonus if, in fact, that one of the salesmen sells the 7 cars. Now, I'm going to reward it a little bit. What if the manager says, I'm going to give a $5,000 bonus to the first salesman this month to sell 7 cars. If you do not sell 7 cars, then find another dealership to work at. What type of contract is that?
Bilateral.
Bilateral, right? Because now it's obligating a second party, because if that person sticks around and tries to sell, you know, they're obligated to a certain extent. Don't worry about express or implied. Ways an offer is terminated is important. If you've taken the test, you know that they love asking about somebody puts an offer and before the offer is received, they die. No good. The offer is terminated. They can't hold them to it. Furthermore, I want you to know withdrawal by offer or. At any point, I want to ask you this question, guys. Who is the offer or originally in the process of a sale of a home?
The buyer.
The owner.
I haven't gotten it right. The seller. The seller is the one that puts his house up for sale, so he's the original offeror. Now, a buyer comes and offers exactly what he wants, then there's an offeree and deal's done. But throughout the course of a normal transaction, they go back and forth and they switch hats. I want you to know when there's a counter offer made, it kills the original offer. So I put my house up for sale for 300 grand, right? And you offer me 285 and I say 290. I can't go back, you know, if I don't hear from you in a few days and say, well, I'll take your 285. I can't hold you to it. Maybe you will, but I can't hold you to it. Make sense?
Yes.
Yes. If the person dies before they buy the house, you withdraw or it's voided?
It's the contract's no good. It's terminated would be the correct answer. Terminated. All right. Remedies for breach. So termination of contracts, don't worry about that. Breach is one, and I went backwards. Remedies for breach. The first one is specific performance, right? Specific performance is where if a party breaches, right, they go to a court of law and they ask a judge to force the party to perform. For example, a seller decides not to sell his house anymore to the buyer for no good reason. You see that on the state as well, right? Can he do that? No. But he's in breach. The buyer can go to court and ask a judge, hey, this guy promised me on the contract. He's trying to back out. He has no good reason. Please have him do as he promised. That's specific performance. Liquidated damages is a remedy for breach only available to the seller if the buyer gave valuable consideration, the deposit, right?
Right.
Then we have rescission. Both parties just cancel. And then compensatory damages is if maybe there wasn't enough of a deposit, anybody wants to be compensated for the damages, they would go to a civil lawsuit and request to be compensated for the damages, right? So that seller that didn't want to sell anymore to the buyer could say, you know what? This guy doesn't want to sell me the house. I'm going to go under compensatory damages. He lost 90 days of my time. I haven't slept in 3 nights, stress, and they can go under compensatory damages. Any questions on these? All right, listing contracts. This is on the state exam and it's important. I want you to know that listing contracts must have a definite expiration date, right? They must not have a automatic renewal clause, because then therefore they don't have a whatchamacallit, definite expiration date. There is no time frame, right, that, for example, you would need as far as a maximum on a listing agreement. You can get a listing agreement for 3 months. You can get a listing agreement for 3 years, okay? I also want you to know that you must return a copy to the seller within 24 hours. Now let's go over the different types of listing agreements. You have an open listing, which is actually unilateral. An open listing is where a seller gives it to a multitude of brokers, as many as he wants. He reserves the right to sell it and not pay, and it doesn't obligate any of those brokers to market the property. An open listing can be a for sale by owner in a classified ad putting, I will pay a broker who brings me a buyer 3%. I read that, I don't have to take him a buyer. But if I read that and take him a buyer, he's got to pay me, right? That's unilateral. Then I'm going to jump to exclusive right of sale. This is the one that's most commonly used. No matter who sells the property, the broker gets paid. The cousin of the owner decides to buy the property, you have an exclusive right. You didn't necessarily procure that buyer, but you're going to get paid. And then lastly, you have an exclusive agency listing. One broker commissioned to listing broker if not sold directly by the owner, usually bilateral. Okay? Now, there's a question on the state exam, and it stems from here, net listing. It doesn't give me enough information to know that it's one of these three, because any of the three can be a net listing. A net listing is where the owner wants X amount of money for his pocket. Anything over that is your commission. But it doesn't say that he's listed it with multiple people. It doesn't say that he listed it with one broker and reserved the right to sell it himself. And it doesn't say that the broker gets paid no matter what. Okay? So the correct answer on that one is net listing. Look out for it on the state. I'm going to share the red slides, and I want you to answer a question that I have on there. $75. All right, I'll wait on a few more. So it seems like we're stuck between B and D. I see a C, I see an A. Let's go back to the definition of exclusive agency. Read it. One broker, commission to listing broker, if not sold directly by owner. In this case, did he sell it directly by owner?
No.
Or did he involved another broker, didn't he?
Yeah.
Forget about what you know about how realtors work, right? That they split their commissions. This is not a realtor test. This is chapter 475. In this case, the one who owes, or the one that is going to be getting paid, is Bob, because Bob has the listing. Now, will Oz probably sue and win in court because he got his wheel spun for no good reason and was working, didn't realize what was going on? It's very possible. But fact is that Bob is going to get paid. You might see that on the state exam.
Excuse me, do you have the question, Jose, where it asks the broker? Sorry, it's similar to the one you just asked, but it's the one you asked me last time, and I'm trying to remember.
I think we went over some of the ones in the 120 together was the thing.
But I'm trying to remember what it was. Sorry, I don't want to. Here, when I come back to it, I'll remind you.
No problem. All right, guys. So I want to go right into the disclosures. All right. So disclosures. I want you to know that they're going to pry at you and make you think that you have to do something more than disclose. You don't. When you have to give these disclosures, all you're doing is telling the truth, right? Hey, this is what's going on. Material defect disclosure. What chapter does that take you back to, and what obligation do you think we need this document for? Chapter 4, ADD, the last D, disclose all known facts and materially affect the value of real property. It goes on to this disclosure, okay? This is what you use to disclose the roof is shot, this outlet doesn't work, blah, blah, blah. Radon gas, this one's on the state exam. They make it look like this house is like lit up in radon gas, and if you walk in there, you're gonna die. So what they're doing is they're trying to pry at you to believe that the seller needs to remediate this, because how dare he sell a house, you know, that's lit up with radon gas, right? All they have to do is disclose. Now they can negotiate, but is the seller obligated to fix anything? No, they are not. Lead-based paint. Here, certain things have to be done. If the property was built prior to 1978, so 1977 and before, the seller and the lessor must provide this. So the lessor as well, a lot of schools don't touch on the fact that the landlord must provide this document to the tenant. They must give 10 days to inspect for lead-based paint. And if lead-based paint is found, well, the seller doesn't have to do anything. But if they agree to remediate it, they must hire a contractor with a special license. HOA disclosure. This is on the state, guys. What must go in the HOA disclosure? The existence of restricted covenants and assessments. The last two is the answer. You also want to know, and this was on the state, I know restricted covenants and assessments have been brought to me by a few students lately, but for a while they were asking if the buyer can waive the 3-day right of rescission period, that they have to read the restricted covenants, and you cannot ask the buyer to waive that period. But no HOA disclosure discloses restricted covenants and assessments. And the last part of chapter 11, the last disclosure I go over is the property tax disclosure. This is on the state, and they try to pry at you with something that's pretty factual. What is the purpose of the property tax disclosure? Well, A says you're going to pay more than what the seller is paying. And in today's market, yeah, that's going to be factual. But that's not the purpose of it. The purpose of it is to tell you that you're going to be paying a different amount. Because in a down market, property taxes are going to go down. Anybody see that question? I definitely, it's been brought to me by several students. So,
Yeah, I saw it.
all right, guys. So that's chapter 11. And what I want to do now is talk a little bit about 10 and then just kind of jump into math. I've given you a lot of mortgage theory. We've covered a lot today compared to some other crams I've done. It seems like a good, bright bunch. Give me 3 minutes. I've been drinking water like there's no tomorrow, and the tank is now just nonstop. And we'll regroup in 3 to 4 minutes, and we'll start with a chapter 10 quick, and that'll take us into some math. You are going to get the 20 questions as well, but I want to talk about debits and credits. That's pretty prevalent right now. So I'll be back in 3. Let me just run the bathrooms literally across the hall from my office. Mia, I'm back. So, the grandpa, right, the testator, left the device, the house, to the devicee, his son. All right. So, chapter 10, meets and bounds. What are the things you need to know about meets and bounds? Meets and bounds, meets refers to distance, bounds refers to direction. You want to know that it is the most accurate plus the oldest. It has a point of beginning. And the easiest one of all that they love to ask on this is what's opposite of north 45 degrees east, for example. Don't change the 45, just north to south, east to west. It used to use inconspicuous markers, like I mentioned, but not by today's standards. So look out for that. Now, the government survey system, right, is the one that's most commonly used. It's mainly on the tests. No, at this point, we're not going to see a slide. I'm going to pull up the screen now to do some math. I'm just giving you off the top of my head here to give you as much as I can before 6 p.m. In the government survey system, right, it is the one that they're going to ask the most on. The first thing they're going to do is which of the following is closest to the principal meridian? Or which is the primary line that runs north and south? They love to ask about the principal meridian. Somehow they don't care about the baseline on that test. The primary line that runs north and south, that's going to be the principal meridian. And then they're going to give you which of the following is closest to the principal meridian. And they'll give you A, B, C, D. And what you're going to choose there is an A, B, C, D, the low R. The number next to R that is the lowest is going to be closest from the principal meridian. Because 6 miles east of the principal meridian is R1E. 12 miles east of the principal meridian is R2E, so on and so forth. And to the west, the same thing. So you don't have to draw this whole thing out. Know that the lowest R of your 4 options, that's the cheat, is going to, go ahead.
Are you showing this?
No, I'm lecturing.
Oh, okay.
I'm lecturing right now.
Oh, okay. Thank you.
I know some of you may be visual, but to draw the state of Florida, right, and then to draw the lines and all of that is going to take a lot of time. So just remember this cheat because you don't have to draw it when you're taking the state. Matter of fact, you can if you're doing it online. Go ahead.
Sorry, if you have the 175 questions, it's number 63, I think, because it says which is the following, like which is closest to the principal meridian.
Yeah, it'll give you that, and it'll give you an explanation. Just know that, you know, from the principal meridian, as you work yourself farther, the numbers grow, right? So the lower R is going to be closest to the principal meridian. Okay. Now, when the range lines and the township lines that run parallel to the baseline intersect, they form something known as a township. And I'm going to draw the township. This township is going to be 6 miles squared. And it's going to have 36 sections in it. And you're going to need to, I don't know if on the online course they're even asking this question right now. I know on the live test they would. Anybody seen this on the online where they ask you what's north of section 14 or anything like that?
Yes.
They do?
Yes.
Wow, they're brutal because if you can't draw it.
Yeah, you literally have to say it and draw. So you have to remember the order the numbers go in.
I'm going to guess the following, and this is kind of what I've been told, is what they'll ask you is, I'm going to number this quickly. You're going to draw 5 lines. And what they're going to ask you always start in the northeast corner. And it's an S pattern. Remember, these people, this was done post-Civil War, horse buggy dragging chains. And you're going to go so on and so forth. This is what I assume And what I was told by one student, I hate to when one student tells me something to share it. I usually wait for two, but I'm going to draw the bottom. And this is why you probably don't need to necessarily remember how to draw this. Is, for example, what's north of section 1?
36.
36.
And that's the
Exactly.
question they asked on the exam.
Exactly. That's what I thought. One student brought it to me, but I hate saying it's on the exam unless two of them do, because it's hearsay when it's one. When two, it's foolproof that two can't invent the story for me. That's what I thought. So it's really easy, right? There's going to be another township up here that's going to have 36. So you don't have to remember how to draw it. Just know that one is in the northeast where you start and you end in the southeast, 36. So therefore, one north of it is going to be 36. If they ask you what was south of 36, there's going to be another number 1 here. That's what I figured it was. Now, inside of these sections, okay, so I'm going to clear this drawing. That's what I thought it was, so I'm glad now and I know 2 students know that's what it is, and I will add it to my list of questions. Clear? Now, each of these sections, we'll say section 14, has 640 acres. And they're going to give you, they're going to ask you, how big is the legal description? And they're going to say the northwest quarter of the southwest quarter of the northeast quarter of section 14. And they're going to ask you how many square feet. They're not going to ask you how many acres. So how do we calculate this? You start with 640. You have to remember that number and divide by the bottom number. There's the first one, the next one, and then one more. 640, 160, 160, 40, 10 acres, right?
Correct.
How do I convert acres into square footage? You have to remember 43, 5, 60. 4 old ladies doing 35 and a 60. So 4, 3, 5, 60 multiplied by 10 is going to give me 435,600 square feet. All right, guys, what I'm going to do real quick is I'm going to pause the recording and I'm going to pull up that question that I have, okay? I don't want them recorded on here. So, and they ask a lot of questions on this, right? So, under Regulation Z, Truth in Lending, a closing disclosure is put together. I want you to know that there's only 2 parties. Yeah, that was the test for 30. There's 2 parties to a real estate closing, the seller or the sellers, and the buyer or the buyers. If one has to pay the other one, right, you're debiting the person who's paying and crediting the one receiving, right? So like prepaid rent, if you have to work out the numbers, and a lot of instructors teach this, it's always a debit to the seller, credit to the buyer. Hey, listen, if you're, yeah, I'm recording. If you are going to be calculating numbers on prorations, yeah, it's usually the seller giving the buyer money. But here are some questions that are on the state exam. How does the documentary stamp tax on the deed show on the closing disclosure? Can anybody tell me how that would show? The documentary stamp tax on the deed. Debit to the seller only. Good, Christopher. How about a newly created mortgage? How would that show on the closing disclosure?
Credit to buyer.
Credit to buyer only. Awesome. You guys got it. This was a good, smart group today. How about a purchase money mortgage? How does that show on the closing disclosure? What's a purchase money mortgage, guys?
Seller financing, so it would be
buyer.
So it would be a debit to the seller because he's not going to be getting that money at closing. We're talking about at closing. And he's going to be giving that to the buyer as a credit. Exactly. Debit to seller, credit to buyer. Now, it's a hell of a racket. He's going to be making a lot of interest over the next years. The earnest money deposit, how does that show on the closing disclosure?
Credit to the buyer.
Credit to the buyer only. Perfect. All right, guys, we got about 5 minutes left together. I just want to kind of open it up. Any questions you may have, I'm going to have to hang out here and let this recording upload, which is going to take about an hour probably. So be patient with me. You might get it late tonight or first thing in the morning.
Quick question about the online test. Does it allow you to go back and forth through the test, or do you have to answer sequentially?
Anybody want to help answer that question? Because I can't 100%.
Yeah, you can go back and forth, and you can flag questions too. So if you get to the end of it, you can review everything.
Thank you.
I was wondering if you could just quickly go over the debit and credit again, just like the beginning.
Okay, so if it is a payment going from one party to the other in the transaction, which there's only two, the seller and the buyer, the one paying would be debited and the one being credited, right, the one receiving would receive a credit.
Oh, okay.
And on the, when it comes to a proration, is that debit to?
Anytime you have to prorate, remember the day of closing belongs to the buyer, right? And the day of closing belongs to the buyer. And if you're having to work out the math, it's always going to be a debit from the seller and a credit to the buyer, such as prepaid rents, such as the property taxes. Those are all paid in arrears, meaning, you know, for example, the property taxes, you live them, then you pay them. The prepaid rents, why? The seller collected at the first of the month. It's only fair that he give the buyer from the day of closing forward.
And then if there's a question about proration and they want, like, will they tell you to do it on a 360 basis or the 365 basis?
Yeah, no, on the state exam, it's 365. You need to know how many days are in each month.
So like, for example, they'll tell you closing is like March 15th. So, you know, March has 31 days and you do it on 31 days.
Correct. Correct. Any other questions, guys? All right, with that said, let me go ahead and then end so that I can patiently wait here for this to record. It was my pleasure. I'm going to get out to you. You're going to email me, right? I'm going to put my email one more time. I'll put my number if you need to text me. Hope everybody got something out of this. I am going to be sending you the number. I'm going to be sending you the PowerPoint, right? The slides. If you were one that paid the $50 online for the class, for the red slides, just let me know when you send me an email. Hey, send me the red slides as well. I purchased them. Okay. Also, I'm going to be sending you the end questions, right? For the math, for being patient with me this morning. And if you do want the red slides and you didn't buy them when you bought it through my site, or you didn't have the option on Eventbrite, let me know you want them and I'll invoice you $10 and I'll give them to you for the same 10 that some of you were able to buy it for. The other ones, they're on my website for 30. The best I could do is 30 if you want them. If not, you got the math from them, man. And the math is great. Let me pause recording.